morning. I'd like to call this meeting of the California State Board of Optometry to order. And first on the agenda, we will have roll call. It looks like we have a quorum. Secretary Michelin.
Ms. Brandwein?
Here.
Dr. Turetsky?
Here.
Ms. Michelin here. Dr. Chawla? Here. Ms. Garcia?
Here.
Dr. Calpucci?
Here.
Dr. McIntyre?
Here.
Mr. Moradami?
Here.
Ms. Salazar-Sperber? Absent. And Dr. Wong?
Here.
Quorum is present.
Thank you very much. Considering we do not have any members of the public to comment on items not on the agenda, we'll move to the next item. So thank you. We're going to go ahead and move into closed session. If I could ask that those who are not participating or who should be present, please step out. And we'll go ahead and shut things down on the recorder and put our placeholder on the webcast. Thank you. Back, everyone. Mr. Moradami stepped out for a moment, and he will be back. We just completed a closed session, and we will continue with item number 4, the President's report. But before we do, could I ask that the door be closed and that if the public would like, thank you.
Hey, Chris,
To introduce
the
yourself.
door locks itself. Can you like shove something in between so it
That's
doesn't?
okay, here we go.
Never mind.
Stick something in the box. And would our two newest attendees like to introduce themselves, please, for the record?
Chris Castrillo, Deputy Director for Board and Bureau Services, Department of Consumer Affairs.
And Sid, I just wanted to clarify for the webcast and the record that initially under agenda item 2, there were no public members in the room, so we didn't ask for public comments not on the agenda, but if you want to revisit that item 2, you can do that.
Perfect, thank you. Do the public members who are here, do you have any comment for items that are not on the agenda? Chris, Kat? Okay, thank you. And do you want to clarify the meaning of that line?
Oh, so for public members, I view that as non-board members, public members that are in the audience. So if board members have comments that are not on the agenda in terms of the Open Meeting Act and compliance with that, I would recommend that be under future agenda items. And in that case, the board members can discuss issues only to the point to decide whether it should be on a future agenda item.
Okay, thank you for that clarification. We'll go ahead now with the President's report, agenda item number 4. So as we're looking at the remaining board and committee meetings that we have before us, an October 5th meeting that will be teleconferenced for this year, as well as November 1st, the Dispensing Optician Committee meeting in Sacramento. November 2nd, the board meeting in Sacramento, and the Practice and Education Committee meetings, as well as meetings to discuss and interview the EO candidates are to be determined. The teleconference committee meetings, the agendas will be forthcoming for those. For the 2019 board and committee meeting schedule, we're looking at January 25th, meeting in Ontario, April 5th, meeting in the Bay Area, August 2nd, meeting in San Diego, and October 25th, meeting in Sacramento. We are currently going to keep the meeting schedule for the committees approximately 1 month before board meetings, and those dates will be discussed by the committees at their next meeting. Does anyone have any questions, conflicts, with any of the dates that have been presented, Dr. Chawla?
I actually do have a conflict with
The April 5th board meeting in the Bay Area. Okay, we'll look at an alternate date for that one, or potential for an alternate date. I'll circle back with staff. Okay. Yes.
I have a conflict on August 2nd. And a comment.
I'll take the comment.
Would it be worthwhile to not do a San Diego meeting at the height of tourist season? Maybe do it in April or October?
And I'd say it's always tourist season.
That's true. And is it worth considering doing a meeting, one of these meetings in a location where we've never really been before, like the Fresno area? That opens it up for Bakersfield, Fresno, Visalia, where there's a lot of folks.
It just, we'll take a look at that and what transportation might be like.
Oh, there's carriages going all the time.
So that the public can get there easily with a nearby airport.
There is a nearby airport,
We will-
Fresno International Airport
We
is
will
nearby.
look at Fresno as a potential.
What was the, and I know in the past we've had a meeting at one of the optometry schools. Is that more expensive or logistically more complicated?
I haven't gone to the meetings that we had at optometry schools. I believe we had it at Western before, but
You got them at Berkeley?
oh, we have, okay. I don't know, I mean, I can check to find out if there were any kind of logistical
The
issues.
one in Pomona, I remember, had zero internet. You could
Oh, maybe
use
that's what it was,
you
yeah.
could use your internet in the room.
And I just think, I remember one of them being really
It was
cramped
downtown
too.
Pomona.
So I think there was, but that's something we could definitely look into as well.
We've had them twice, a couple of times.
Okay.
They put us in the vision lab, which is the crap one.
Yeah.
And then Berkeley, because I know we had looked at, Jessica had asked me 2 years ago, and the
They're like a
the facilities are really small. So I mean, there's only really 2 large lecture halls, and then they're all used during the day for lectures. So
Okay.
I just know that, otherwise we would have to pay.
Okay. All right.
One
We'll,
more quick comment. You haven't had one in the Los Angeles area in a while, and I've had some questions about that, so just, passing that along.
I'll add that to the
It's kind of a big city.
LA question mark. Okay. All right. Agenda item number 5, board meeting minutes, Secretary Michelin.
So before you, you have the draft meetings from April 20th, board meeting in the Bay Area. I believe it was circulated to all of you prior to the board meeting, so I don't have any comments or edits that were sent to staff, but I'm looking for a motion and a second to approve the minutes.
Any comments from board members? Anyone like to make a motion?
Motion to accept minutes.
Do I have a second?
I'll second.
All those in favor, we'll take a roll call.
Dr. Tretzky.
Aye.
Ms. Michelin, aye. Ms. Garcia.
Aye.
Dr. Calvucci.
Aye.
Dr. McIntyre.
Aye.
Mr. Mordami.
Aye.
Maria Salazar Scribbers is absent. Dr. Wong
Aye.
and Dr. Chawla
Stay.
and Ms. Grandine.
Aye.
Motion carries.
No abstentions. Okay, thank you. Go ahead with the interim EO report.
Sure. So agenda item number 6 is the interim executive officer's report, and this is by Joanne Wenzel. She's the interim executive officer. I'm sure many of you are aware of that. The first item on there is the update, which was prepared by our former executive officer, Jessica Sieferman, and this is on the Association of Regulatory Boards of Optometry meeting that she was at in June. So she has a pretty lengthy summary, I think, of all the discussions that occurred during this meeting, along with some recommendations for the board to consider as well. So I'll just highlight those. That way you can go straight to the action, and that was highlighted in red. So the first item that she reviewed as far as having a recommendation attached was the move to a paperless system with regard to license verification. Currently, we still issue license verifications just via paper right now, so if another board needs to find out about the standing of one of our licensees, that's done the traditional way. And what she is recommending, and what one of the other boards communicated during the meeting, is that they are going paperless. So they are recommending that or referring boards to contact them, and I believe this was Virginia board, that they go to a specific website, the license verification, and that's how they can look up that particular licensee. This is something that was demonstrated during one of our previous board meetings. I know that a couple of gentlemen from the Breeze team demonstrated the license verification website, which is, I mean, it's a really, really nice site that they came up with. So she also included a sample letter from the Virginia board, which I think we could utilize as kind of a base to send out to the other boards, possibly have Ms. Brandwein sign it, just advising them that in order to get license verification, they should go to a specific site and that they can get the verification that way. And that just furthers our efforts to go fully paperless. Obviously, we want to try to do that in any form that we can. So that was one of the recommendations.
I have a question.
Mm-hmm.
Who's looking at this license? I could be missing something here.
Another board of optometry. So I mean, if
But we're already online, don't they? Can't they just?
I just looked up.
I mean, you can look at my license.
right, and this, I mean, that license verification site is linked to where they are online, but that's how we could do the license verifications instead of actually doing something where we need to print out a certain certificate, have it signed by the executive officer, and then send it via regular mail. We can simply say, go to the license verification site so that we don't have to do that. And if you need to verify it, the license is in good standing, because that's the standard practice right now.
Okay.
So it's just one more step to eliminate the need to have staff or the executive officer involved printing out something, mailing it,
So
and saying,
there's this, we're saying this as a formal verification
Right.
versus having to have a signature to
exactly.
make it formal
Yep.
verification. Got it? Okay.
So,
Yes.
thank you, Dave, for that question. I'm slowly understanding, but I'm reading the recommendation and the plain language doesn't make any sense to me. So can you state what the recommendation is again? Staff recommends that this board set a similar policy directing boards '(s) to DCA.
So the policy would be, and I think it was the state of Virginia, like I said, that came up with moving to going paperless. So their policy now that they've implemented is not issuing license verifications on traditional paper snail mail. Their policy is, this is what you need to do. So they sent out a letter to the associate or other boards, other state boards saying, if you need a license verification for this state, here's where you go. And so that's advising them of where they need to go from then on. So if we adopt a similar policy to say, we're not going to issue those paper license verifications, you need to go to our specific website with the link there to verify licensure, then we can also implement that similar policy. Send out a similar letter to advise them of it, and then basically just push any of those inquiries in that direction.
It's a policy change.
So directing, when it says directing boards, she's talking about directing other state boards.
So basically,
Right.
so can I make a, do we need a
Wait a
motion?
second. So BORD'(s) is
Oh, there is.
correct.
It's not.
Not
Okay,
office
okay.
board. I
So
can-
do we need a motion?
Right, the apostrophe, yeah.
Or do we need to put this on for future agenda item
To have further discussion?
to have further discussion? This is just a report out from what's.
You can take action on items without actually saying it. So I'm comfortable if you want to vote on that's the direction you want to move now without having future, if you think there's something that staff should come back with and report on and have further discussion about, you could go on the future.
I would move that staff draft a letter for the board president, correct me if I'm wrong, Rob, to send to all other licensing boards in other states that they need to go through the online verification process to verify license of California optometrists. And I'd also like to make sure that it's put on the homepage of the website so that people can go directly to the website and get it that way as well.
Right.
Is that?
That captures,
Okay.
I think that captures pretty much what Jessica was conveying.
Okay, there's a motion on the floor. Is there a second?
Second.
Thank you. Dr. Kawaguchi, discussion, comments from board members?
Question.
Dr. Tressi.
Rob, how do you see this, their CAQH, which is the sort of the clearinghouse for VSP, they want to, or INET, they want to be sure that we have malpractice insurance and a license and all the other things. So all that stuff is uploaded to the CAQH website, and they just access it as they need. So one of the things is that you have a copy of your paper license on file with them. Would we now just say tell CAQH to go to the website to verify it? Or would we still get the paper license and send it to them? It doesn't require anything from the board, from the EO signing off on anything.
Right. I couldn't speak to that. I mean, I would imagine that this would also
So we're just
accomplish
talking
that task.
strictly about other regulatory boards and not about private.
Yeah, I don't know what the requirements would specifically be and whether that would satisfy. I mean, I would
We're not
assume
getting
so.
rid of the paper license if we still need it.
You can print it off, right?
Yeah, you can print it
So
off.
you can print it, you can go online to yours and then just print it off and then send it to CAQH.
Okay. All right.
And I think that was the goal too of this license verification, is just to, you can view it online. If you need to print it out and submit it to another entity, then, that's obviously an option as well.
Okay.
It's kind of for the other entities to decide, so.
Right.
I mean, at Kaiser, they don't ask us for a printed thing anymore because I mentioned you can just go look at it. So, we said it, now they do it. So I think it's a matter of those entities deciding.
But I think they were just unlocking it right there.
Okay.
Okay.
Do we have to vote?
Oh, yeah. You had a second, I think you had a second.
Yeah. Yeah.
Okay. No more comment?
I'm going to do public comment.
Any public comment?
Dr. Turetsky.
Aye.
Ms. Michelin, aye. Dr. Chawla.
Aye.
Ms. Garcia.
Aye.
Dr. Kawaguchi.
Aye.
Dr. McIntyre.
Aye.
Mr. Morinami.
Aye.
Dr. Wong.
Aye.
Ms. Graham.
Aye.
Motion carries.
The next item that Ms. Sieferman summarized, had a recommendation on, had to do with the OE tracker, and this has come up multiple times, but there was a presentation during the meeting highlighting the OE tracker's mobile capabilities. It sounds actually pretty interesting. OE tracker is a pretty useful tool when it comes to having audits performed for enforcement. It just makes it that much easier when we select someone for an audit and they provide us with their OE tracker number. We can go on there, see what courses are completed. Obviously, it's a regulation that those courses via OE tracker are proof of completion of those courses, which is great. And then I believe OE tracker also sections them out into, this is specifically for glaucoma or whatever it may be. So it makes the audits that much quicker. And I know with speaking with enforcement, the audits, and we've been very, I guess we're trying to get a lot of audits done right now. So we have a lot of them in play. We're trying to do a pretty large percentage of our population. But there has been some back and forth with enforcement because some of these audits are taking a lot longer than we originally expected. And I've seen some of the packets that we get sent, and it's sometimes just stacks of papers that we have to go through. Sometimes we have to get the PEC committee involved when there's a particular course where we're not sure where it would fall in our CE requirements, get a response there. So OE Tracker, anytime somebody's using it, it makes it that much easier to do these audits. So the mobile app, it looks like it's allowing QR codes to be read. So if a provider has a QR code, they can simply scan it on the mobile app, and then it instantly updates it and uploads it to their OE Tracker profile. They can also take a picture of the certificate. It gets uploaded. It takes a couple of days to get that done because one of the good things about OE Tracker is that they also validate the courses that are there. They don't simply just store it, they also validate those courses. So that does take a couple of days, but it gets put up there as well. So the recommendation is to partner with ARPA to provide some outreach regarding the app, and then hopefully the results of that increased outreach would result in increased usage of OE Tracker, which would offset any extra work that we have to do for the audits and basically make it so that our audits can be that much more efficient. So that's...
But correct me if I'm wrong, there's a fee to use OE Tracker.
Mm-hmm.
And we're not mandating though that optometrist has, so it's an option.
It is.
So we're just saying, hey, here's an option that you
Right,
use.
and I'm not sure what percentage of the population uses OE Tracker right now.
So my other question is, when we had this discussion before, We had asked Jessica to go back to DCA and to, where is the status of Breeze being able to utilize and do some of this?
I'm not sure. I have to check with the chief because I know she did bring it up to him, and it seems like it is something that they would be able to do. But there are a lot of X factors involved with that, to where we would have to get some of that information from OE Tracker, because, like I said, that is one of the things that it does do is it also validates it. So just because our system accepts it, it doesn't necessarily make it that much faster. If it simply just stores it, that validation is also a huge part of it as well. So there are a lot of intricacies that go into implementing that, but of course that's something that we want to continue to look into before we make a decision to say this is the way it needs to be.
So don't you use OE Tracker?
I do.
Do you pay like a per course or do you pay like a monthly
It's for
or yearly?
a year or 3 years.
Right. So if the state ever got to a point where they were able to do it internally, then you could always make a choice to train. You're not in a long-term contract.
Refresh my memory. OE Tracker is a private app, right? Is that
It's through ARBO, so it's via the Associated Regulatory Boards of Optometry.
So it's an ARBO product.
Correct.
Still private
I mean,
though. Still private.
Yeah, I would maintain it was. Yeah, I mean, I would assume it was created and maintained by
For our
private company.
okay, I mean, I just, that lessens my concern a little bit, although I'm not, I would just ask staff to just keep an eye on how ARBO advertises it, or, because I wouldn't want something on the ARBO website that says endorsed by the California State Board of Optometry.
Right. Right.
Well, another thing attached to that comment is, I believe that they get some funding to support the program from private corporations.
Like Allergan is on the website.
So that's another question mark that we have as a board, and how much we can be involved in that based on that.
And we had also talked about if we started with Breeze, we would sort of be in the forefront. And there are a lot of other boards that have continuing education requirements. So if we were to start, dentistry, medical, veterinary, everyone has CE that they have to complete.
Yeah, and I would imagine that the results of that,
It would be better.
conversation and figuring out what we can do would result in a global change to Breeze. So that definitely would have, I think, implications to all the other boards we're going to face as well, because I'm sure they would want to hop on and they utilize that.
The biggest thing you have to look at is, can you do it? Can you validate the legitimacy of the course?
Right.
And then, can I take a course anywhere? And like, put that in, because with their system, I got it when I was a student and it was free, right? This is like years ago. And they've just, and they've updated and improved their system because it was clunky at the beginning, but it was free, and so they were like, oh, okay. And they really improved it. So, you should look at the model anyway. You should look at the model because it's not a bad one at all. And it's fairly universal where you can, like, all the big courses. I just look for code courses anyway.
Right.
Right?
Makes
Unless
sense.
we approve our own, but I look for code courses and that's easy enough. And it's a good partner because the courses are valid. It's not going to be questioned. Or denied, and that's the big thing, because I don't want to take courses and then have to go on these 8 units don't count, right? So you want to make sure you have that in place, and how much does that cost to do? I think it's worthwhile if it's, but the validity of the course is key. So, but I would encourage you to look at their model and see if you can do something.
Right, yeah, and I mean, we're trying to have the Breeze product work for us and our board in a number of different ways, just to implement different things that are going to make it easier. But like I said, with this particular item, as it relates to OE Tracker, I think the way that it's implemented right now, as far as the way it functions, it does make the audits a lot easier. So
It's not just that, you're asking what percentage, I don't know the percentages, but I know that more and more, because as optometrists graduate, they're more technologically savvy, they're
Right.
not just being able to scan stuff.
definitely,
So we still have quite a few optometrists that don't do those
Right.
things, so, but there are a fair amount that actually want to use it. So it's definitely a nice option, and it's a good, not just looking, it's easy for me to
Mhm.
track what I do.
right,
So those are benefits if you ever wanted to say, well, this is a nice thing to do, whatever system you wind not a bad thing. But you don't want to force people, because like we do have a lot of optometrists who just.
Won't do it, yeah.
Yeah.
Oh, yeah, definitely.
So this is a report out from the meeting, and if there's action that the board wants to take, I suggest, because there's a lot of discussion, we consider it for a future agenda item. And then we'll continue going through the report.
It's fine.
So do we want to defer then the outreach for utilization
I
of the
think
mobile
that
apps?
was pretty, I know on the OE tracker, when we had a discussion before, there were people who came and spoke out. So I think if we're gonna do something with the OE tracker, I agree it should be an agenda item. I think the other one is pretty, it's just sending out information.
The license verification?
Yeah, I mean, that's not.
There was one more recommendation.
Yes. The next one, I believe, had to do with the NBO, and this has also come to our attention. So there was, let's see here. There was a presentation on the NBO exams, and it highlighted that there's going to be a six time limit to taking the exam. And this has come up in the past where we have spoken with some people who have taken it more than 6 times, but they are imposing that limit. And this is going to have some implications as far as increasing the security of the exam, reducing the likelihood of a unqualified candidate from passing, maybe increase their motivation in studying and being prepared for it. And then it looks like they determined that the scores tend to stop improving after the second or third attempt. The recommendation in this case is to reach out to NBO, and I think it looks like it's her name is Ms. Bryant, so that we can be apprised of any technical difficulties with the exam during the testing or shortly thereafter. If they could, and I can talk to her about this, provide us with some quarterly stats on basically invalid scores, which would be suspected cheating, the appeals that result from that, and then the results of those appeals, if that's possible. So I think this is just more informational stuff that we want to find out, and I think it's stuff that's good to know, because I know that this has come before the board before when it comes to the actual examinations. So I think any information that we can continue to get is important.
Dr. Wong, didn't we ask that they provide us with any instances of technical difficulty?
So, that was like 2 years ago.
When we had the phone call with Dr. Terry?
When we had our lovely phone call, yes.
Right.
Since then though, so there's part 1, part 2, part 3, and at that time, part 1 was still paper. And this past year, part 1 has now become computerized. So it's my understanding that there's 4 tests that are going on at the same time. They're all computerized at computerized stations. And within each one of those computerized stations, the test questions don't match the person next to them. So they randomize the test questions. So looking at the stats now, the number of suspicious incidences, they don't call it cheating yet,
Right.
have decreased significantly. So, but I still think it would be a good idea
Yeah.
for us just to get the reports. But yeah, we did ask for that report at least 2 years ago.
Well, I do know Dr. Terry is no longer with,
He is no longer
Yeah.
with us.
but I can follow up.
So would the board like to make a motion to request formal action on this item?
I'll make that motion.
Do I have a second?
I'll second it.
Thank you.
And when you say formal action, you're directing Rob to
Directing, exactly.
reach out to Ms. Bryant.
I get a roll call. Further discussion and public comment. So public comment, Kat, do you have anything? Okay.
Dr. Turetsky.
Aye.
Ms. Michelin, aye. Dr. Cholo.
Aye.
Ms. Garcia.
Aye.
Dr. Capucci.
Aye.
Dr. McIntyre.
Aye.
Mr. Mordami stepped out. Dr. Wong.
Aye.
Ms. Brandon.
Aye.
Motion carries.
Thank you.
I have a quick question before, just a question on the OA tracker, please. Can we is it appropriate to direct staff to get more information so when we do
That's a good
agendize it?
idea.
To get more information, like to find out more about OA tracker and their policies, to figure out what Breeze can do, is that appropriate?
That I think we can. We can do that.
So I'd like to make a motion to direct staff to research OE tracker and how it's run, and then see if there's a complementary system that can be implemented into Breeze, including costs and benefits to optometrists on the board alike.
Maybe can we get the head tech person that does Breeze?
I think so.
And it's
We can
email,
certainly
so
ask.
we can ask questions.
Yeah.
kind of show what we're.
Is that a comment or an amendment? Are you amending the motion?
Well, I
to
would
include
have
that?
that
It's
included
part of
in
the research, it's the
Okay.
research.
Is it a motion for that or no? Right?
Well,
It
it
wouldn't
wouldn't
hurt.
It wouldn't hurt,
Correct it.
okay.
So
Yes.
that's the motion.
Okay,
Second.
thank you. Any comment from the board, public, Kat, Chris? No. All right.
Dr. Turetsky.
Aye.
Ms. Michelin, aye. Dr. Chava. Ms. Garcia. Dr. Calvucci.
Aye.
Dr. McIntyre. Mr. Mondani.
Abstain?
Dr. Wong.
Aye.
Ms. Grandma.
Aye.
Motion passes.
Okay, and I think that was it for, yeah, those are the recommendations that Jessica put forth, and of course, I want to thank her for providing this update. I know she's very busy over at the Veterinary Medical Board, but certainly appreciative for getting this document.
And for clarification, we sent her while she was still executive officer. So we did ask for a report following, that was part of the approval process for her to continue to go. Okay.
So I can take the FBI Rat Back program update because I reached out to Ms. Sieberman and asked her about what the board should be updated on. As you recall, the FBI Rat Back, it's actually, I have to look this up, but the RAP stands for Records of Arrest and Prosecution, and BAC stands for Background, and it allows the notifications and updates with including arrests and charges that do not end up in convictions to be reported subsequent to the initial background check reporting. And while the Department of Justice had told DCA and Jessica that they would be inviting statewide stakeholder meetings on that, there hasn't been much movement on it. DCA has continued to remind the Department of Justice that this board has a strong interest in it and having those meetings. And apparently Jessica believes that the Department of Justice, their position is that their statewide system does not meet the system requirements for this FBI Rat Back program. But Jessica Sieberman advises that the board, there's new legislation, and the board may wish to seek assistance from the legislature through legislative means during the 2019 session. And we've included this legislation under agenda item 9B, so I'm just going to give it a preview and then we can discuss whether we want to actually take action on it. But that legislation is now requiring the Department of Justice to provide the FBI subsequent arrest records to the Department of Social Services, the Medical Board, and the Osteopathic Medical Board. And Ms. Sieberman recommended that you may want to support, if amended, to include the Board of Optometry in the bill. And she advised that it's set for a Senate appropriation hearing when they convene on August 6th. And she also said that even if it's too late to get that amendment through for the board, the good news is that she believes if it goes through, the Department of Justice will be required to update their system and to accommodate the working with the FBI Rat Back program. So it's possible that they'd be more willing to work with the Board of Optometry, even though it's not a requirement in legislation.
Okay. And then the next item is the strat plan. So I utilized the previous update that Ms. Sieberman had during the prior board meeting, and then just added some updates in red. I can quickly run through those. So in the first goal for licensing, one of the things to take note of it is we did create a cloud drive for the schools of optometry. I believe at Berkeley we already had something established where they're emailing us the transcripts, but we did confer with the registrars at SCCO and Western, and they were very receptive to the idea of converting the transcripts to a PDF form and then utilizing this secure cloud drive. I had to do a demonstration for both of them. But we were very grateful that they were able to do this for us, because we're trying to do anything we can to make the process quicker for licensure. So them being able to just drop the transcripts into a cloud drive and for our licensing team to just access it right there instantly makes it that much faster. They don't need to send it via snail mail. We also raised a SIR, which is basically a ticket in Breeze lingo, and that is to separate the exam request from the application for licensure for optometrists. Currently, the application begins kind of at the exam request level, and the board staff has to get involved. But when Jessica and I looked at the actual law, in order to take the exam, they only need to be 18 years of age and be basically interested in becoming a licensed optometrist. So we made it, we kind of pulled that transaction part of it away from the original transaction as a whole and made it to where an applicant can hop on, say, yes, I'm 18, I'm interested in becoming an optometrist, click submit, and it'll automatically approve. So there's no need for board interaction in this case, so it's one less piece that we need to deal with. And then the exam vendor will contact them, they'll take the exam, and then they'll be able to request the application for licensure. I think this is also really appropriate because it's going to be more accurate when we're tracking the actual cycle times of our applications. Because it doesn't seem right to say when somebody's requesting an exam and the time between them taking the exam, applying for licensure, providing all what's required for licensure, it makes it appear that that cycle time is all on us, when in reality it's not. So by taking that out and having them have full control over that exam request, that's what we're accomplishing with that. So that's a ticket that's in place. We're still
Can
working
you
on
back
that.
up 1 second?
Sure.
Going back to the schools in California using the ability to electronically send the transcripts.
Right.
Have any of them, so the other 2 schools, Western and
Yes.
yeah, did they actually try it? Have they started doing it at all?
Oh yeah, that's how we've been doing it.
So they have.
Yep. We established the cloud drive, and I get emails. Not as often right now, but I was getting a bunch of emails at the beginning. I was forwarding that to the licensing team because it actually alerts us when something has been dropped off into that cloud drive. And then the files, we spoke with them and said, we need a naming convention so it's easy to link that file with the actual applicant. So I think they're using just last name or whatever format that may be, and then they can just upload those onto that person's application in Breeze. So it just
So it's
makes
working well.
It's working well, yeah.
So have we communicated with any of the schools in the US, Canada?
To reach out to them. We haven't reached out to other schools, so I'd say this was more of a pilot, but I think it's really successful. But I think that would be something to definitely consider is expanding that to other schools and trying to get them on board with utilizing the cloud drive. I think like I said, anything that we can do to make it easier is great. But I think
So therefore, would you consider that a part of this strategic plan still to now expand that out to?
Yes.
Okay.
I would.
Is that like on the website or anywhere, so people who are applying can just let their schools of optometry know that they can just submit it through the cloud?
It's not, because I think we have to set that up with the school. So from an internal board perspective, we're gonna have to reach out to, whoever, SUNY or whoever it may be and say, hey, Mr. and Mrs. Registrar, here's this cloud drive. We wanna, I don't wanna say sell them on it, but we wanna explain why it's a benefit to their students who wanna become licensed in California. I would assume that we've kind of taken care of the lion's share, because I'm guessing that a lot of the, SCCO, Western, and Berkeley, those are the ones who are really going to get licensed in California. But I think reaching out to the other schools, I think, would be really invaluable.
And you think it's improved the processing time?
Yeah.
Do we know how long it's been taking? I only ask because
Right.
I've had multiple emails and texts from at least Berkeley students asking when they're going to get their license.
I don't know what we have as far as the current estimation on cycle times. And I know that you had asked about that earlier, and I do want to look into those specific cases, because I don't want to paint with a broad brush and say it takes this long or it's taken them this long in this particular case, because I think if they haven't provided everything required, or let's say they provided everything 6 months ago, but then they were still missing something else, and they just provided it, they're saying, well, I've been waiting 6 months. It's like, no, we were waiting on this part of it.
I just know
Because-
that 2 weeks, I guess I sent you an email 2 weeks ago. I was getting numerous emails and texts saying, I still don't have my license.
Right, and that's why I wanted to touch base with you and see if I could get some specific examples so I could look at their applications. And of course, if there is some kind of inefficiency or something that I need to address with staff, I want to be able to do that.
Well, sometimes it's variable by different schools of optometry. So some schools of optometry respond very quickly to those kind of requests. In others, it takes them longer because of administrative realities that they deal with. So by creating a tool for them that makes it easier, hopefully that will speed the process for all the optometry schools.
Yeah, and I know that, I mean, there was a little bit, I'm not gonna say of that, but I think I kind of had to let them know the benefits of that, because there is a little bit more work on their side, so instead of having to just print and mail out the transcripts, they do have to convert it to a PDF, add a name to it, and then send it over in the cloud. But I think explaining that this is a benefit to their students and it's going to get them licensed faster, and hoping that they can meet us halfway and help us out, I think we would really appreciate that they were willing to do that.
So does it show through a status bar perhaps of where it is, or if additional information has been requested, or if it's in the final stage of review?
On their application, when they're viewing it, or?
And through, so it goes into a cloud system, but then what?
So basically, it'll notify me that there's been something uploaded to the cloud, and this is just the transcripts.
Right?
I'll alert the licensing lead that we have received something in the cloud. She'll go on there and pull that document out and then basically attach it to the application. And so that will satisfy that educational requirement part of the application. But of course, there could be other things that we're waiting on as well. So whether they haven't done their fingerprints, or maybe they haven't taken a certain exam, those are still outstanding. That's not going to specifically call that out, like if they hopped onto their profile, it's not going to say you're missing this, this, and this. It basically just says pending at that point. But with the application process, there's a lot of correspondence as far as phone calls, all that kind of stuff. So they're definitely able to communicate with us, but yeah, it's not going to tell them you're missing this, this, and this. It's just going to say pending.
Is there an opportunity to automate it even further so that they know, instead of just saying pending and text messages or emails going over to Dr. Wong or others? It seems to me we might want to look in the future how to make it completely convenient.
Yeah, I think there could be something as far as if they hop on their profile, where we could maybe. I mean, I'd have to see how we can implement that,
Okay.
but that could be possible as far as making it so that instead of saying pending on maybe another section in the profile, it could reflect the missing items or missing transaction items, possibly.
So this could be a Breeze update request. Like, I know we have kind of an ongoing list of things that we want Breeze to be able to do, so this could be something that's on that list of things that we want.
Right, and the thing I think to take into account when it comes to these updates is there is a priority system, obviously, that the change control board has to go through when there's a major system update. Luckily, our former executive officer is the chair of that board, so maybe we've got a little pull there. But I know that there is a priority system. So when there's a major change, or there's something that has to be done, it has to do with legislation or something that needs to be implemented, it really takes priority. There's a couple other items on here as well that kind of reflect that. I was going to touch on that briefly, but that would go in the queue, and they'd have to determine, if and then when that would get done.
Because this would be a benefit to all boards, so.
Yeah.
And I think this would definitely decrease the number of phone calls, because I know that one of the complaints, or one of the issues is that people have to take time away to answer the phone, but if you could just go online to your profile and check and say, look, I have everything, what's going on, versus like, oh, I didn't realize I was missing this one document.
Well, and one of the things that we do, and I'll have to touch with the licensing, but I know one of the things that we've been instructing them to do is to use that publish feature, because I know it's basically what it is, and I think this is another item on there as well, but we can publish a specific document to their profile so that only they see it. So when they log into their profile, they can look at documents. So what we want to do is have the deficiency letter that we normally send out and say we also need X, Y, and Z, publish that document there. That way they can view the profile, and yeah, let's say pending, but hey, here's a new document that says I'm missing X, Y, and Z. So it kind of helps in that respect, because they're aware of it, but I understand what you're saying, because it'd be nice to have something that's updated live.
And updated. Okay, if you can add that to the list, it's the bottom line.
And I have a question. I know with opticians, we don't have an education requirement at this point, but at Moore Park, the students are required to do light scanning, fingerprinting. And I'm wondering, would that serve for their registration?
No.
It wouldn't have to be something different?
Yeah, with fingerprints, anytime you're fingerprinted for a specific entity, that entity is entitled to the results of those fingerprints. So it's not going to be shared. It's the same thing if, I was fingerprinted when I came on with the board. If I go to a different state organization and there's fingerprints required, I'm going to have to get fingerprinted through them as well. So it's very specific, and I know with fingerprints it's very touchy, and I know a lot of things came to light during our audit because we want to make sure that we only have access to the things that we should have access to with regard to fingerprints. So yeah, they still need to get fingerprinted with us.
But if we do, as the DOC talks about education requirements, then maybe we start implementing something on Breeze as well. If that were to come up, it's still something pending in the future.
Mhm.
That would also work with the.
Yeah, I mean, any way that we can further utilize Breeze for our purposes, I think we want to do that.
Yeah, I hope so. Thank you.
Sure. We developed some content for the summer newsletter, and this is just highlighting more so our paperless renewals. I'll try and go through these pretty quickly. I raised another ticket to remove the automated printing and mailing certificates. This should be, this is, I'm not going to say a long-term thing, but it's a system change. So when there's a major system change to Breeze, other boards need to be on board, and they have to approve it as well. So it's something I'm going to have to sell to the other boards and explain why it's a benefit. So basically what this is in a nutshell is instead of relying on certificates being generated, so the wall and pocket certificate being generated and mailed out, instead of that, in our effort to go paperless, we would have that certificate still generate, but it would be converted to a PDF and automatically published to that person's profile. So that was something that I was talking about earlier with, that's just their profile, that's not the public profile, it's theirs. But they'd be able to hop on there, click on the link to that specific document, print it out, post it if they want, but it would be right there, rather than them waiting for it to come traditional mail. Obviously, we're saving, as far as, in our efforts to go green, and it allows them access immediately to that specific document. So if they are working in a temporary capacity, they can go on their profile and bring it up on their phone and say, here's my license right here, because essentially it's just going to be a PDF of what they would normally get, and that isn't really printed out on a specific type of paper or anything. We're still going to have the engraved certificates printed because that's on a nice paper and it's something you want framed, and that's upon initial licensure and registration. But I think the renewal licenses that are generated, I think being able to have those easily accessible right on the profile, I think is what we're trying to accomplish there. So that could be another good one. Let's see. So working with Breeze teams show PDF documents on dashboards. Okay, I mentioned that. OA project is on schedule. 2 meetings with subject matter experts have occurred. OPS is drafting the pilot survey. They just contacted me about it last night, so I'm going to have to review that survey. It'll get sent out in August. The OA for RDO, the BCP has been submitted, so we'll wait for an update on that. But they're going to begin that OA for the RDO program, I believe, this month. But I'll have to talk to Todd. We'll talk with OPS to find out what's necessary and the timeframes there. Obviously, we were directed, it hasn't begun yet, but to work on merging the optometry and RDO funds. The inspection program was deferred for a year based on a report of the proactive inspections. AB 2461, I think Mina's going to touch on that a little bit later, and this is just regarding the FBI arrest records. Increasing the working relationships with other divisions. One of them was meeting with the Northern Area Commander. I recently spoke with the Southern Area Commander, so we're establishing good relationships with DFI, just because we want to make sure that the inspections and investigations that we receive are exactly what we're looking for, and when problems arise that we're in the loop. And they're really receptive to it. They've got a great team there and I think great leadership, so we want to continue to have that good relationship. And then I think that's basically it for the strat plan.
Only when you're finished.
No, that's for that particular year.
So I have an observation and a question. My observation is, wow, we've bit off a lot in the strategic plan.
And that is something that I guess I should have touched on. Yeah, we did bite off a lot.
Wait till I finish.
Sorry. The coffee's kicking in. Sorry.
We've bit off a lot. I appreciate the staff's efforts to meet the elements of the strategic plan. But in the context of the next item in the executive director's report, I've observed that there's a lot of staff turnover as well. And I think, and then this kind of relates to our relationship with the DCA, the department, and that is, I'm sure the staff turnover is going to hamper or inhibit our ability to meet our goals in the strategic plan. So would you not agree that we need the support of the department in terms of helping us hire a new executive director and providing temporary personnel to fill in the staff turnover, that we need the help of the department in order to meet our strategic plan goals in a timely manner? Would you agree with that?
I would agree, but I definitely, I don't want to downplay what DCA has done for us just over this past year, because I know that we've thanked them on multiple occasions for providing us with temporary staff members, and they have been a lifesaver in a lot of occasions. We have had some turnover. There's some more listed here. We're trying to be as proactive and as agile as possible to deal with it. But of course, I mean, at any opportunity, I will reach out to DCA and say, hey, is there anything we can get help with? But I know that they are definitely willing, and we've had multiple meetings with them to help us out. And that's what's really great is we have their support.
That's
So-
great to hear. Thank you.
I have a question, I wanted to wait till the end as well. I really like how there's a development with ARBO because of all the optometrists. There are, not exactly like ARBO, but at least maybe 3 or 4 organizations that do work with opticians and their development. So for research, I would imagine the staff wants to be available and understand what they're doing. Would you like me to provide you at least the names of those organizations?
Sure, yeah, definitely.
And so that you can start connecting with them?
Yes, yes,
Okay,
absolutely.
I will send it to you and it'll say research.
Please. Okay.
Any other questions or comments on the strat line?
Okay, so next up is the enforcement update. I'm going to have Cherie Kimball, our enforcement lead, just give us a synopsis there.
So in June, the enforcement unit attended a symposium put on by our biological fluid testing vendor, FS Solutions. It was highly educational. We learned about new illicit drugs that are available, the updates in the ways that biological fluid testing happens, the different types of testing and what it covers, like time frame wise, so how long a urine test will test for, how long blood test, hair and follicle testing, that sort of thing. So it kind of gave, like as a probation monitor, it gave me a better idea of what tools we have available to us to monitor the recovery of our substance abusing licensees. So it was very educational, it was a great symposium. Speaking to staff turnover, at the end of July, our analyst, Kelly Flores, accepted a promotion to the Bureau of Cannabis Control. So she has left us. We're sad to see her go, but very excited for her. It was a joy to watch her grow while she was with us, and she's left some very big shoes to fill. And the enforcement program continues to prioritize the oldest pending cases as well as the high priority and expedited priority cases. In the fourth quarter, we transmitted 3 priority cases to the Attorney General's office, and the average age of those cases was 229 days. So I think we're doing a pretty good job of staying on top of those. And we saw a 35% increase in the number of complaints received in quarter 4, and the RDO program had a 20% increase in closures in quarter 4. So are there any questions about the enforcement program?
Thank you for being very forthright about the average age of cases transmitted to the Attorney General. From a lay perspective, 229 days sounds like a long time, especially for high priority cases. Without getting into the details of any one particular case, maybe from kind of a 10,000 foot view, what are the usual causes for the delay, or what takes time? I won't call it, but what takes time getting to the Attorney General for these high priority cases, and what suggestions might you have for the board as to what we can do, either regulatorily, resource, or legislatively to expedite?
So depending on the specific case, for a high priority case, it may go to the Division of Investigation for a field investigation to be conducted where they actually go out and interview the respondent, interview the complainant, collect documents or evidence. The case could have gone to an expert witness who would review the information provided and make an opinion on whether the standard of care was met or if there was a deviation or negligence, that sort of thing. Sometimes what we're waiting for is another agency to provide us records, and as we all know, in state service, workload can be high, and sometimes it can take a while for those things to happen.
So are there any issues of, the DOI or another agency, or let's start with DOI saying, sorry, we can't get to it for a certain period of time?
For our higher priority cases, DMI has been very responsive for getting the investigations done in a timely manner.
Okay. And in terms of having an expert witness, are there any delays in terms of finding the expert witnesses, the expert witness taking a long time to come up with their opinion?
Typically, when we have a high priority case that goes to an expert, we let them know that it's a high priority case, so it moves kind of to the front of the line, and they typically get those back to us relatively quickly.
Okay. And do we have a stable of expert witnesses that we can go to right away, or is there time spent kind of looking for?
We have ones that we use. I think that we could always use more, so that we have more options and a variety, especially when we have several cases that need to go to an expert witness. But we do have ones that we use regularly.
Okay, so finding an expert witness is not a problem.
Right.
Okay. And in terms of the agencies that we need to get information from, you don't have to tell me which agencies there are, but I guess if there are agencies that we go to regularly and they regularly create delays, maybe that should be discussed at some point where we can communicate to that agency and say, gee, you're holding us up and you're doing it regularly. And maybe that's something an action that we can take.
One of the things that we have done, there's a particular agency that requires us to put the request on their specific forms, and it has to include specific information, signatures, that sort of thing. For this specific agency, that's become part of our process. So we have their forms, we know what they need, and that kind of cuts down the time from us sending their request for information and having them send it back and say, no, we need this. We're already sending it on their approved forms.
Okay, all right. So I guess if there's an agency that's unduly delaying the request for information,
we're doing our best to tackle that.
right,
Yes.
and I welcome you to let us know about that, we call them out.
Okay.
And then I was just going to mention quickly, just to your question, I think we've discussed it before, is a lot of these high priority cases might come as a result of a notification of a settlement, and that can be problematic as well, just because the patient who's affected, a lot of times they might have already received their compensation, I guess. And so when we try to contact that attorney or the patient directly, we a lot of times won't receive a response because they feel like they've already been made whole. So we kind of have to reach out to them via email, calling them, sending them multiple letters to say, hey, we want to make sure that we look into this case to ensure that this person is safe to practice because that's part of our process. But that does add to the investigation time.
Well, I understand the reticence of a patient to communicate with us because it's, it could be traumatic if you just move forward. Why can't we reach out directly to the licensee?
Oh no, and we will. We will reach out to the licensee. I think there are some times where they, because we need to get both the release from the patient, any of the related records. So if that patient went to another doctor after the fact, we would want to receive those records as well. But yeah, we can definitely reach out to licensing. I know there are times where we've reached out and they've provided us everything we've needed. There are other times where they've only provided us a little bit and we need to go to that patient to get what we need. So that does factor into the time frame as well.
And question.
What qualifies as high priority, and who decides what is high, low, medium priority?
So the priority is set, and it was reported in the sunset report, and I don't have it memorized, I apologize. It was originally set by DCA as far as what types of cases rise to a level of high priority. One of those is actual patient harm. So in cases where a patient may be lost vision as the result of the optometrist's action or lack of action, that would be considered a high priority case.
Thank you.
And one other question, and Mia, probably to you too on this. Something comes across your desk and there's a criminal action involved, and you're really worried that this is somebody who could actually do harm to, that somebody that's been convicted of elder abuse, child abuse, running a meth lab in their apartment, something like that. Can the board take action to suspend that person's license immediately without having to go through all the necessary steps?
Depending on the situation, we have a couple of different options available to us. There's an interim suspension order where Deputy Attorney General represents the board to an attorney law judge and requests that an interim suspension order is granted. So basically what that does is it immediately suspends the license, and we have to file an accusation within a certain number of days and move forward with the case. The other option in criminal matters is we can appear before the criminal judge and request that as part of their bail, they are prohibited from practicing, and that's called a PC-23 order. It's part of the penal code section.
Would you know that this is going on while their case is being adjudicated, or would you not know anything until after there's already been a verdict?
So we get notification from Department of Justice when a person has been arrested, and so if that arrest is concerning enough to us for whatever reason, we would then go to the Attorney General's office and request that a Deputy Attorney General go and represent us in criminal court. As part of the criminal proceedings, that, like I said, if you're released on bail, as part of your bail conditions, you cannot practice. And then that becomes a matter of the public record.
Any other questions for Sheree? Thank you very much.
Thank you.
Okay, so I'll just touch real quick on the remaining items. So examination, we reviewed that just to go over the OA, the Occupational Analysis update. The workshops, as far as the exam workshops they've been no problem. Todd's been on it. We've been having them full every time. Quick update for licensing. Jessica and I attended, or we presented to the 2 Southern California Schools of Optometry, just to talk about the enforcement and licensing program. We'd like to continue, well not we, but I think the board should continue doing this. I think it's really valuable. I don't know if Dr. Wong can agree with that, but I think it's a really good venue for us to connect with the students to ask us questions, just cover some frequently asked items, let them know what's happening, and I think one of the big parts is to encourage them to get involved in the profession. We even tell them to apply to become a board member, an expert witness for reviewing cases or being involved in the workshops. So I think it's a really good opportunity, and we still get the questions that are after. They want to talk to us, one-on-one about something that's happened that might be related to enforcement, and we're happy to answer those as well. And I think it just kind of alleviates any stress they have or anything they're concerned with as far as thinking we're just some faceless government organization who's out to get them. So I think it does set their mind at ease. As far as furthering our mission to go paperless, I did provide some training to the licensing staff as far as manually publishing. I know I mentioned we want Breeze to automatically do it, but manually publishing certificates to that licensee's profile, so that's something they're implementing now. So anybody who is recently licensed or registered, part of that process is to generate that certificate, convert it to a PDF, and upload it to their profile. So they should be able to access that now. And that's just to kind of test it and make that just part of the process. All documents, as far as an application goes, should be contained in Breeze. Another effort to go paperless, we want to make it so that if you go into an application and you're on the Breeze system, the back office system, there shouldn't be a document hanging out somewhere else or in a different folder somewhere. Everything needs to be scanned in, all the correspondence, any notes, everything. That way, any one of us, especially this kind of talks to turnover and being able to pick up where someone left off, should be able to go into that application and know exactly what's going on. And so that's one of the other things that we've implemented that is the directive right now. And then there's some licensing stats below. Let's see. The personnel update, we did lose Abby, who was loaned to us by DCA, but we're very thankful once again. Priscilla Torres Fuentes returned from her maternity leave, so we're happy to have her back. She was eager to get started. Let's see what else. And then Jessica Swan, our RDO coordinator, was out on a leave of absence, and she's returned. So she's back at the helm as far as taking over the RDO applications. I want to thank Brad Gardy, who worked in a limited term capacity as the RDO coordinator, but he also floated back and forth between enforcement just to make sure that we didn't lose any ground. I think I mentioned at the prior board meetings that we had posted a limited term position in enforcement to make up for him being over in RDO, but we did have to repost that a couple of times because we didn't find a candidate that we felt was a good fit, and I didn't want to settle. We did increase the RDO position from a 0.9 to a full-time position, and that's because we did have a 0.1 position left over from when we created Alex Suarez's position. We had a 0.1 position left over, and that's floating out there, so we went ahead and made that a full-time position. And the work definitely speaks to being a full-time position. And then once again, Kelly Flores has moved on. So we do have a vacancy. It has been posted, and I think it was probably a 10-day posting, but once that is done, I'll start going through the applications, setting up interviews, and hopefully we'll have somebody in there, hopefully next month, depending on who we can find. Obviously, there is a process there, but I'm going to try and get it filled as quickly as possible so we don't lose ground. Yes?
So I'm observing folks that start with us jump to other DCA boards. And you can answer this question offline, but I'm wondering, are we like the Oakland A's? Where
The farm team.
pay our employees like low salaries until they start performing really well, and then they jump to the Yankees or the Dodgers or our salaries.
I like to think it's the A's. I think one of the things to consider is that our board is small. So if someone is looking to move up, sometimes they feel that the only opportunity for them to get into management is to move into a board with a couple hundred people. I think what it speaks to when they're going to other boards or other DCA is that DCA is a really tight-knit family. And I know that I've experienced that when I go to headquarters. You see all these people that you know constantly. So it does feel like more of a family atmosphere. And I know I've seen some of the survey results about people loving DCA. So they really love the DCA family and they want to stay there. It's just our board is very small. So if someone wants to be a manager, and there are a lot of our staff who wants to get out into management or move up into the AGBA position if they're simply an analyst level. But one of the other things that we do from a management perspective is I don't want to hamstring their efforts in growing. So when they want to train or take management courses or expand their knowledge so that they can be more desirable in a promotional position, I don't want to hamper that and say, no, I want to keep you here. I certainly want training all the time because I think it's valuable. It makes them a more productive employee and happier in what they're doing, knowing that they're striving for something else. So yeah, we do lose them, and it is tough, but I understand that's just part of it, and I don't want to go the opposite way by trying to say, you're stuck here.
I agree with your answer. It's a great answer. I'm happy to be the Oakland A's.
Yeah, we're nurturing the talent.
And if one of us is Billy B, that's great. So fine.
All right. And then next is the budget item. This was provided last night from Wilbur. If there's any questions, I think we can relay those back to him and we can get some updates there. But that's basically it for the interim executive officers.
Our budget balance is in good shape.
Yes, I believe so, yeah. Yeah.
Any questions on the budget from any of the board?
I'm sorry,
Yes.
related to the report, and backing up to connections with the students, at the optometry schools, is there an opportunity to have the information that's provided on our website easily accessible to students that may be graduating or going to be graduating from other schools in other states?
Yeah.
So, can you add that also to our little breeze?
For outreach, yeah.
Yeah.
That shouldn't be a problem. And I know that's something that comes up after the presentations is that sometimes, either the administrator or the students will say, hey, can I get a copy of that PowerPoint? And, that's totally fine. We want to be transparent. Jessica and I provide our actual, direct line so that, hey, if you need to call somebody, call us. And we want to be that accessible.
And
So, yeah.
the presentations have been really positive. The students, the feedback I got from the students, they're very appreciative. You guys take the time to talk to them.
Good. That's good to know.
It makes the board seem much more approachable.
Yeah, and that's what
They're like
concern is.
real people.
Yes,
This is-
exactly. We're just people. We're not applications.
Thank you. All right, from an agenda standpoint, we're going to go ahead and take a break. A quick break to stretch our legs, grab our lunch. Lunch will be brought in, and then we'll come back for a working session. So if we're back, please, by the bottom of the hour, 12:30, we'll continue on with the agenda and go from there. So we will take a short break. Thank you, everyone. We're back in session for agenda item number 7, the executive officer recruitment and selection process. I could have committee member Rachel Michelin provide an update with input from Dr. Lillian Wong.
So as of today, we have 2 applications. Dr. Wong and I have been working with DCA and made a decision yesterday, day before, this week, to extend the filing deadline an additional 30 days. It has been posted on the Capital Morning Report, and I just got an email from the Capital Daybook. It was posted there as well. At this point, I think that we need every board member to step up and take one action in what they're going to do to promote this position. I know I personally put it on my LinkedIn page. My organization has emailed it out to a couple of thousand email addresses, but we all are going to need to promote this position and get the information out, or else in another 30 days we're
It is small.
yeah.
So, it was just posted
No.
in the last
No,
couple
it was posted,
Okay,
but we reposted it.
okay.
So we extended the deadline.
From 30 days to
Another
Right,
30
but I
days.
didn't know how long it's been out there. So
It's been out there for 30 days.
The full 30.
I know there was a little lag time in getting it emailed out to the listserv from the board. So hopefully we can resend that out with a big headline that it's been extended.
Okay.
Also, there's a way we can put it on the homepage for the board, so it's right there on the homepage. The challenge right now is there are a lot of executive officer positions open. And so there's, and unfortunately, some of these pay more than what we're able to pay. So, Nicole emails us every Friday with an update. So really, I think it's up to us to individually, I know some of you, the reality is this person will probably come from the Sacramento region just because the job is based in Sacramento. Doesn't mean it can't be someone from outside. But particularly those of you who belong to different associations, labor unions, different groups, if you can send out the job posting, if you have a LinkedIn, if you have Facebook, whatever you have that you can get the word out. And if you have any questions, email me. I can send you what I put on my LinkedIn page with a link to the Cal HR. That would be great. Lillian, if you have any comments.
I mean, I think, well, Nicole had said also that often, a lot of the applications don't come in until towards the end of the 30-day process, so I was waiting for it.
Me
It
too.
wasn't yet, and it was very disappointing to see.
Yeah. Yeah.
And then I also, I did reach out to Lisa Fennell over at Arbo,
Oh,
and post the position to the
Oh,
other
great.
boards of optometry.
Great, thank
So she
you.
said she was gonna do that for us.
Thank you. Is that enough?
Mr. Bordeaux?
Yes.
Mayor?
So why do the other boards pay more than we do?
Why don't we invite Mr. Chris Castillo from DCA to come join us?
Well, I'll and correct me if I'm wrong, I think part of it is, based on what the agency will, I mean, we can make a recommendation, but it has to be approved by the agency secretary, and ultimately it's still a position that is under the jurisdiction of the governor's office. So it's, I think it has to go through that process. Am I wrong or right? Am I making
Yeah,
stuff up?
yeah, no,
Yourself?
yeah, there's no, Chris Castrillo, Department of Consumer Affairs. Load question, complex question. Each of our boards under DCA, each of our bureaus under DCA are slotted in a different level. I think I've reported to this board previously that we're going in under an executive officer salary study, contracting with a third party. A big part of that is taking a look at the levels that all of our programs are slotted at, trying to better understand why they are slotted there. And you are right, Rachel, this isn't DCA saying program, optometry here, med board here, architects here. This is a process that involves and predates me by a wide margin, but involves our agency, governor's office, Cal HR, and the department. So there's no real straightforward answer in terms of why is optometry in the place that it is. I mean, I think generally speaking, some of the things that we definitely want to take a look at is what's the staff size, what's the size of the budget, what's the size of the licensee population, how many license types are these boards handing out, what's the level of complexity of the Practice Act and how has that changed over the years when the board was originally slotted in that position. So those are some of the questions that we hope to have asked as part of the salary study. But Mark, it's a fair question. I mean, it's a complicated one, and it's one we're going to try to do a little bit of digging on. But Rachel touched on.
The study's supposed to be done.
So yeah, I was going to include it in my.
Oh, sorry.
No, it's fine. I mean, I'm here. It's so we recently I just signed the contract for the consulting group that's going to be performing the study. We are going to have the award posted, if not today. There's some rules around how long it needs to be posted for before it's started, but we inked the contract and we're going to be having a sit-down kickoff meeting with the group very, very shortly to get that process underway. And then we're looking at about a 6-month project timeline. We want to get this thing wrapped up by early February.
So one suggestion I would make to your point that I thought about, I don't know if we can do it. I would say that if after this next 30-day posting, if we're still in the same position that we're in, where we really don't have a diverse pool of applicants, at least, right now, I don't even know that it's not worth your time because I think you have to have more than just 2 people. Maybe at that point, Ms. Brandwein can go back to DCA, maybe we can look at, maybe there's an opportunity to some wiggle room in the salary, I have no idea, but at least if we've done our due diligence, and I think that's where it comes back, if every board member can do their due diligence so that we know that, each one of us has taken responsibility to get the word out, to tap into our networks, and we still aren't getting a qualified pool of candidates, the right diverse pool of candidates, and maybe there's some arguments there to see what we can do. But I think at this point, all we can do is continue to promote the position, get information out to folks, all people we might know, so that we can hopefully get some more individuals applying.
So if I can make a comment, To your point about what the board is like, it's very different, you know, than the profession of optometry has evolved so much in the past 20 years. So what we do now is so different from what we did before. And Dr. McIntyre, I was just talking about this at the break, optometrists are notoriously bad at promoting themselves. So, and the same thing goes for our boards, you know. So I've seen the quality of the board members from, not that they were bad at the beginning of when I, you know, joined, but it's just gotten so much more and more. It's just like elevated to a level that's, you know, very, very good. You know, and I think that you have to look at what we do now versus what we did the last time this position was evaluated, which I don't know what it was, but it's so different. Even in the last decade, you can go back 20 years, but even in the last decade, it's very different. And responsibilities. And now we actually have another program here. So it's not just the optometry board, there's the opticians are there now too, and you know, there's a lot.
My guess is they took the RDO program from the med board, they probably did decrease the salary of the executive officer of the medical board, and she has less, you know, she doesn't have this program. So I agree, and I know that I totally get where you're coming from, and that's why, to your point, I think our job is for the next 30 days to do our due diligence and show that we're doing everything we can. And then if we still don't, then I'm hopeful DCA will work with us and help, because we only have Joanne for a certain amount of time before she's going to be gone under her deal with as a retired annuitant. And then, you know, and I don't know, you know, what happens then.
So Chris and I, together with the bureau chief, had many a phone call, literally within the first hour that I received notice, and it was daily for a good couple of weeks, and now I think we speak maybe once or twice a week for a fair amount of time. So they're well aware of our needs, our desires, how the position has changed. To Dr. Chawla's point, how it has totally evolved, and given them numbers of optometrists, numbers of RDOs, even specific bullet points as to what in the job description has changed from our viewpoint, from your viewpoint, and updating that document. It's been a dynamic, but it's been a very good two-way conversation and a good partnership. So whatever we can do at the end of this 30 days, to your point, list the exact steps we've taken. That would help me in my next call with Chris and Dean.
Just really a quick follow-up, you know, the RDO program, you know, you mentioned about the medical board, which led me to this comment, is that it was kind of dormant there. You know? And so it's not just, oh, we got the RDO program, we're reestablishing, or I don't even know if that's even the right word, because I don't know that it was very well established, because they just didn't have the time, you know, to do it. So it's a brand new thing, from like almost from the ground up. You know, so that's a lot of work for everybody to undertake.
Building the education program that goes with it, the certifications that we're talking about.
Yeah, and I had to comment that it is a lot of work, and there's still so much more that needs to come out. I know the DOC is helping right now, they're accomplishing quite a bit. We'll be ready to help the new EO, but I still think it's going to be a lot on their plate. And something I think the board needs to look at, is it going to be too much for them? And what else can we do?
I would say, I think, I'm sure that, I know Chris has heard us over and over again on this, and I think right now it's our responsibility.
Right.
And so I'm asking each of you, and if you could let Lillian and I know, maybe just shoot us an email, say, hey, I posted it on my LinkedIn, hey, I sent it out to, these are the different groups I sent it out, and then we can keep track so that we can let Nicole know at DCA, this is the outreach the board's doing. And then also at the end of the 30 days, if we've all exhausted our networks and we still don't have a pool of candidates, and we're going to have to brainstorm on what we do next. And I think that's where Nicole's going to have to help us.
I'm just looking at the board's webpage. We don't have anything on the homepage.
I already asked that.
I know. It's kind of
So,
hard to find something you
If
can't find.
I know somebody who's interested, if I knew somebody who was interested, where do I tell them to go?
There's a link, I can send you the link.
Can we make it as difficult as possible though?
The board's Facebook page
It's,
has it pinned as the top post, so no matter what we post on the board's Facebook page, it'll always say it as the main post. It's pinned there, so that's a decent enough spot for it gets them on the page of the actual board website.
I'm on the board website, there's nothing there.
Oh, no, it's on the Facebook page.
Oh, I don't belong to this Facebook thing.
It's very tricky to.
Can we get anything on this DCA?
well, so DCA's posted it, it's on their LinkedIn, I already looked, it's on their LinkedIn page. I know that DCA has sent it out. What I can do is, forward the job posting. Well, can I send it to, can I send it to you and then you make sure everyone has it fresh on their email? Should I send it to you, Rob? Who can send it out to the whole board?
To the board, yeah, I can send it, yeah. I can send it to the board, and then I can also contact the internet team and have them update our website.
So what I'll do is I'll just forward this that came from Nicole that just has the link to the job posting, and then Rob, you can just send it out to everybody, and then you all have it, and just send them the link, and that's the
Get it
way.
posted on the website.
Yeah.
Another, so, Alex Kim has some insanely large network of people who are into doing these types of things. He was a board member in the past. He's on a different board now, actually.
He just got appointed.
Different board, he got appointed to a third position, so I'll send it to him. He's constantly growing his network, and he's always encouraging public service, and so that's something.
And I haven't even started to get out to everybody. So
You can send it to the DOC.
That's right. All of them, and also all of the RDAs.
There is on the DCA webpage though, a request for public members for the Structural Pest Control Board. So, but there's nothing here for the Board of Optometry.
Well, and I just think at this point, DCA, Board of Optometry, they can do their thing. We've got to do something individually. We've got to, it's our hire, kind of. So we really need to, I think Alex is a great idea. I don't know if COA has sent it out. I think they put me off the list. Like I'm talking about fake news. Mr. Murdoch.
So of course, thank you for that answer. It's a reasonable answer and a careful approach to this. I think I might ask staff, can you send me the names of some boards that are comparable to our board in terms of, licensees, budget maybe, and because it doesn't take much, maybe Rachel or Dr. Lang wants to do it. Go onto the website Transparent California and plug in the name of that board and see what the EO salary is. And you can see whether the Board of Potted Plants executive director pays the same or less or more or comparable.
So you
Well, can I just make a comment on that? I appreciate what you're trying to do, but at this point, there's nothing we can do about the salary. I'm saying at this point, I think the priority is getting the word out.
I heard you.
I'm really,
Let me get to my second point, because I get addresses what you're saying. I get it that the executive officer for the Board of Optometry will not be paid as much as the executive officers for the the medical, right? More licensees, or the candidates probably. I get it, right? But I think there's something special about this agency and this board that is appealing to an applicant that might make up for the difference in pay. And I think we should individually think about what that is and be able to articulate to a possible applicant. Yeah, we may pay less than the medical board, but this is what you can do with the Board of Optometry that you can't do there. I don't know what that is right now, but I think that's something that we should think about.
Are there career development opportunities that we're able to commit to, for example, or mention association meetings to make it all a part of this broader package? broach that with the team yet, but
Maybe like put the job posting out to like association.
aside from salary, when we start talking to these folks, can the board commit, for example, annual attendance at Arbo meeting, or 2 professional association classes, 1 within state, 1 out of state, sponsored by the state? I mean, how can we also build a package that might be a little bit more appealing than here's $3.75 an hour plus,
I don't know. That would be a question that if Rachel, Lillian were interested in, maybe exploring a little more with our HR chief, Nicole. I'd like to further on that.
Okay.
Yeah.
Because,
I hear you.
Yeah.
Some, how can you,
and there appear to be more wiggle room for someone who comes from outside of DCA than from within, if I understood correctly. If someone is a transfer, for example, or moves between departments, there's a cap on what they're able to get in the way of a salary increase, versus someone who comes from the outside. We have a range, and the board makes a recommendation where on that range someone can be. I find it kind of ironic in some respects.
so my experience has been, generally speaking, so not generally speaking, for sure, you all are within the Board of Optometry's range. That's a defined salary range for whoever you're going to bring into this position. My experience has been generally that person does come in at the bottom of that range and then can work their way up. I think you're kind of asking the question of someone whose previous salary might have been within, like maybe somewhere closer to the middle. So, they're always going to be within that range. I haven't really generally seen somebody come in above or much above the minimum of that range to start. So,
I'm not sure if Sid was asking about the salary. I think Sid was talking about other stuff about this position that makes it enticing to someone from the outside. I mean, enticing, exciting. I don't know what those things are. I could give you some time I can think of them.
I'm sorry.
You're
Just
gonna
being Sacramento, and I'll speak for Chris. Charlotte mentioned.
Yeah, and the healthcare benefits.
Yeah, healthcare benefits, my husband works for the state. Healthcare benefits and pension for anybody my age or younger is not, you can't compete with it in an 401k environment. I mean, it's an insured monthly pension is where, and Chris, I'll let you finish that.
So
It seemed like an obvious that needed to be said.
So if you look at the Commission on the Status of Women and Girls, they're hiring an executive officer right now. It's right smack dab, first thing you see on their homepage, and then when you click on the link under what's new, it looks like they typed up their own little job description with a link to the Cal HR. Maybe Lily and I could put a little sales pitch together, and if we can, how fast can we get that on our website?
I think I can contact the internet team and get it posted.
So if we get,
Depending on what I talk, I can probably get it posted pretty quick.
alright, so we'll do that, and then what I'll do, Rob, is we can send you the link to the commission office, so you can show them this is how
Sure.
they want it. That way you don't have to recreate it.
Yeah.
And I think in that, we can put in some stuff about and maybe have Nicole help us in terms of what the healthcare benefits and, all of that kind of thing. Once that's done, though, I keep wanting to bring it back, all of us have to be promoting the position. Because the only way we're gonna be able to have any ability to go back to DCA should we not get more applicants is if we've all done our due diligence. And I think the job ends, when is it, September 4th or something?
So we have about a month, yeah.
We have 30 days from today.
It's today or yesterday?
Well, today was the filing deadline. I think it's like
9/4, September 4th.
Fourth, yes, the 4th, this is the Labor Day weekend.
And have you reached out to any associations that we should be aware of, that we're not doubling effort? Okay, so let's
I've
start
done
from
personal
scratch.
stuff. I've done my own organization and sent it out to probably over 10,000 emails in the state. And I've posted on my LinkedIn, I had over 500 views of the job. So people are interested if we put it out there.
Okay.
And if you need help on LinkedIn, call, I'm happy to help you.
And Rob is
Just
sending
once
me
again,
some
where is the application for you to apply?
I'm sorry?
How do we tell them to go and apply? Is
You
it-
have to go to the link, you have to go to the Cal HR site, it's very specific on it, and it's pretty straightforward. You have to file, you apply online, I don't even think they send, do they attach their resume? I can't remember.
There's a resume, there's a resume.
Yeah, it's very specific, if they sign a duty statement, then they need to acknowledge it, so they need to go to the HR site, and the link, I just sent Rob the link, and he can forward it out, yeah, and you just send that to people.
It's a very obvious application.
Yeah, it's, yeah.
Is it on COA right now, do you see it?
Say anything, but I'm not on the other side, I'll take a look to see what's
Okay, nothing's jumping out on the COA site, so maybe we can solicit their support. Any other comments on this topic before I ask Chris to stay where he is to deliver the next agenda item? All right, thank you both. We'll all take our own personal actions to post and do and reach out to our communities that we're involved in. Agenda, we're going to take one out of order. Agenda item number 10, update by representative of Department of Consumer Affairs. Chris, all yours.
Thank you very much. Thank you for taking me. Again, Chris Castrillo, Deputy Director for Board Bureau Services, Department of Consumer Affairs. You talk about EO recruitment, Rachel, and I know you've both been very active in working with Nicole. I want to say, we're very committed to all the entire board to make sure you guys get the best candidate you can. So appreciate the work you all have been doing already. And then just wanted to make sure I started by congratulating Mr. Chapucci, Ms. Wong, and Mr. Moradoni on your recent reappointment to the board. Obviously, very, very happy to have you all running a fantastic job on the board. So really pleased to see that. Thank you for your service. Just wanted to provide a couple of quick updates just on, what have we been doing up here at the executive office. As you know, often when we come here, the director can really focus on outreach to each of our programs, continuing that thread. Back in June, we had our director's leadership call. So many on the board, and Rob, I know you're familiar with the director's quarterly meeting that we have with our executive officers from all of our programs, bring them together along with our executive staff, help them sort of draft an agenda for items that we are sort of mutual importance to our programs. Once a year, that director's quarterly has also included board presidents and vice presidents. Our director's been looking for other ways to engage with our board leadership. So this director's leadership call that we did back in June, sort of our first go around of this, where we're doing a conference call for board presidents and vice presidents for all of our boards. So in a similar fashion, ideally, that we bring together also executive officers for a quarterly meeting. We are also looking to engage our board leadership for a quarterly meeting. I think our first go around was pretty good. We did a conference call. Sometimes those can go a little crazy. We had an opportunity to do a mute function. People were able to submit questions via email. We had our Board Bureau Services email inbox just open live and submit your questions as we go and kind of answer them on the fly. Covered a number of updates, talked a little bit about pro rata, Assembly Bill 2138, provided an update on the executive officer salary study, which I mentioned to you all just a little while ago. And so, again, thought it was successful. We're going to try to go ahead and do another one at some point this year. Date still to be determined, but please stay tuned for that. And then I did mention the director's quarterly for our executive officers. Our next one's going to be on Monday, August 6th, and so Rob or Joanne, whoever ends up being available, obviously would love to have you there. We're going to have a pretty robust agenda, and just so folks are aware, as part of that, I think what's generating some interest amongst a lot of our programs is we're going to have a presentation from the Department of General Services, and this is looking quite ahead into the future, but they have a plan in 2024 to essentially construct a new state office building in the Richards Boulevard area of Sacramento that's going to house the entirety of our agency, the Business Consumer Services and Housing Agency, which would include all of DCA's programs, presumably. Again, just sort of the draft plans sort of been released. But, we think that's gonna be a really big draw for our programs. Obviously, a lot of interest in building, moving, again, farther down the road, but they're gonna be there to present a little bit on what their thoughts are, what's kind of the process looking like in the next 6.5 or so years before that takes place. So we're really looking forward to that conversation. Reported on a couple of times, we've been spearheading these licensing and enforcement work groups. I think we started back in April. We did a joint licensing and enforcement, whether it be executive officers, licensing staff, enforcement staff, and have since then kind of separated them out into that we have a licensing work group and an enforcement work group. They're meeting monthly, so 1 month we'll have the licensing, next month we'll have the enforcement. We've done 5 meetings up until this point. Most recently, we had our enforcement work group. We had the Attorney General's office come and speak about their enforcement report, talk a little bit about Attorney General timelines. The whole goal for these work groups is to get sort of the subject matter experts from each of our programs in the room, what's working on the licensing side, what's working on the enforcement side, what isn't working on the licensing side, what isn't working on the enforcement side, get programs and frankly staff who are working in similar areas, and even though each of our programs have different licensees, different license types, I think our feeling is kind of the root of licensing and enforcement, the basics of it are actually fairly similar across the board. And if we can have programs that are doing certain things really well, help pick up some of the programs that may have struggled in certain areas and vice versa, that we can collectively sort of improve, whether that be timelines or just the ability to carry out licensing and enforcement tasks in a more efficient manner. That's the goal of these work groups, and so they've been going fairly well. We're getting a lot of interest from each of our programs. You talked about Cloud Drive a little bit earlier, or most recent licensing work group. We had a presentation from the Board of Registered Nursing, who has their own Cloud Drive for nursing schools to be able to provide their curriculum, what's the word when I have a transcript, it's been a while since I graduated college, to be able to put that information in Cloud Drive, so just, a repository of sorts, so now staff can really easily grab that instead of, hey, I'm waiting in the mail for something. So those are the kind of things that we're looking for programs to share and hopefully find simple ways for other programs to implement things like that. Another convening that my office has been spearheading is the Substance Abuse Coordination Committee. And this is the executive officers from each of our healing arts boards. And specifically, we're taking a look at Uniform Standard number 4, and that has to deal with drug testing frequency for all of our substance abusing licensees who are in a diversion program or under probation for substance use. It's been 2 meetings of very robust discussion. I think First Source Solutions was mentioned earlier in the board meeting. We have a number of stakeholders across the industry taking a look at what's the recent developments in drug testing. Is there new methodologies? Is there new technology? To help us kind of get to the core of this question is I guess just put it another way, can we right size the number of times that a substance abusing licensee in a program should be drug tested throughout the course of the year? It's been a really good conversation. I think randomicity has been highlighted as whatever you do with the number, that's got to be the key component. And then, of course, always trying to balance public protection, which is paramount, and ensuring that the program is accessible for folks who need it and can stand to benefit from it. We are working on putting together our next meeting, looking like that's going to be sometime late September, early October. And so whether that's Joanne or your new executive officer by that time, or we can always designate a certain member of your staff to sit in and attend that meeting. But that's been an ongoing effort and certainly one that we're taking a close look at.
Can I stop you on
Yeah,
that?
for sure.
Just a quick question,
Yes.
because I know this board, as well as the DOC committee, that makes recommendations to this board. They're looking to make revisions to their current disciplinary guidelines. Of course, those incorporate uniform standards and conditions related to that. Do you know from your meetings whether other boards and bureaus are kind of putting a pause on any regulatory changes to those guidelines until this specific issue is resolved?
Excuse me. So Not specifically a pause, but we do have, and we've started kind of conversations with our legal team at DCA on if the committee were to, implement changes, the committee decides, hey, we want to change uniform standard in, these 4 particular ways. What's the kind of process for that? Does that mean new regulations for each of our board go out? Is there sort of a blanket regulation that DCA can put out and boards can kind of implement? So I think what our boards are, I guess, waiting for is what are the changes going to be, and then how those changes would be put into reality. And then I think at that point, our boards will make a decision about, okay, what do we do then with our disciplinary standards and everything else down the line. Is that
Helpful.
okay?
It's like, at least it's out, it's being considered, that
Yes.
issue.
Yeah.
Work through
Yeah.
people, maybe connect with more communication about the process, and I'll follow up with my legal colleagues too, on what they're doing.
And then so last item for kick back to you all, if you have any questions, of course. Board member orientation training. I don't know that anybody here, actually these I think you all square, but you need it. September 18th is going to be our next meeting. Then we have one on December 5th, and then just so you all know, start looking at the calendar for 2019. 2019, we haven't established dates yet, but we are looking to do, we've got some interest from a number of our board members across all of our boards to do a board member orientation training in the LA area. It's something that the Department of Design has done in the past. I think we have enough critical mass to warrant at least one meeting down in Los Angeles and kind of on a trial basis. Trying to balance, making sure we got enough folks to justify to bring down people from DCA to do this. Same time, I want to make sure it's convenient as we can for our board members who live in the LA area. We have, as you know, a lot of programs under DCA, which means a lot of board members, and we do have a lot of board members from the LA area. So it's looking like we're going to have at least one board member orientation training down in LA. Date and location still obviously to be determined, but once we get the 2019 dates set, we'll be sure to share those with you.
Do you know what's required in 2019, like sexual harassment to do? I can't remember.
Yeah, that will be a sexual harassment prevention training year, and then with any of our newly appointed or reappointed board members, within 1 year of their appointment or reappointment. So I mean, I have 3 of you sitting right in front of me. You'll need to do that within a year.
And how often is the ethics? Is that every 2 years too? Ethics training? How many hours?
Should have brought my training quiz me.
It seemed like they were all together.
Yeah.
On
And
the
even
even
defensive driving?
That's cool.
Oh, the training.
That's every 4 years?
Okay, so I'm not for that.
You're up for that too? I'm sure you'll email us.
You know where to find me if you have a question.
Well, no, I'm sure you will find me if I haven't done all of my training.
2-way street, that's fair. That's all I have, but happy to answer any questions you all might have.
Question in the back, Anita, will come forward. You could introduce yourself, please.
Anahita Crawford, Deputy Attorney General. I would like to encourage, if possible, since there's already discussions on the drug testing, that there be discussions on whether the facilities that do the drug tests and maintain those records perhaps be in the state of California. From a prosecution standpoint, once the board's determined that there's a reason to move forward with a petition to revoke probation on individuals who are drug testing positive, we have had pretty difficult times with the facilities that are out of state trying to get records and trying to get medical examiners to come and testify and validate the tests. So if they're in state, it would make that so much easier.
Any other public comments? Chris? Thank you very much. We're covered.
Cool.
Thanks again.
Thank you.
And thanks for your help on the EO.
We're standing by to continue helping you all.
Thank you. Appreciate it. All right, agenda item number 8. Update, discussion, and possible action regarding board committee reports. So let's just move move down the line, please. Consumer Protection Committee update.
So, let me ask a procedural question in terms of a time check. In discussion with staff, it's clear that we will not be able to take any final action on this item, but I would like to give an overview of what's happening so far in this process over the disciplinary guidelines from a 30,000 foot level. So, how much time do we have for that? And advising the chair and the board that we won't have a final decision. So if there are other things that need to be done right away, have to wait.
We're moving through the committee reports. I know no other committee report that has a dynamic
Can I
topic.
make a suggestion? Do you want to power through all the other reports, then do him?
Why I was saying that there's none that I think have as dynamic of a discussion. So do you mind if you hold, let's move through the rest, we can come back to yours.
Happy to.
Okay. So public relations and outreach, if you could please.
You're my
Yeah,
guy,
that's-
Sharon, if he wants to.
That's fine.
Okay.
Okay, so the update on this is, it looks like it's pretty straightforward. During the last committee meeting, discussion was made over doing a new board logo. So we were provided with 15, I think, different options, 13 different options, which you should have been provided. The recommendation was logo 5, and that kind of has a little blue swirly around it. And then I know Dr. Kretz kind of mentioned that he liked our current logo as well. So I think at this point we just have to make a determination on whether we want to proceed with redoing our logo to now be logo number 5 or continue with what we have right now.
And is that something we need to do now as a motion, or you're just reporting on the committee?
No, I think the committee, we moved to have the board, we voted on one.
On 5.
To go forward. So I will make a motion that the board accept the new logo.
I'll second that.
Any more comments from board members on the topic? Comments from the public? That would be a no. Mr. Morgami.
So, I have to admit, I didn't know we were even considering this. My question is, what are the costs in changing the logo? I imagine you have to put up new stationery.
Well, here's what I would recommend, is I think there's very little cost to change it on the website.
Yeah, the electronic side, yeah.
How much letterhead do you have, you know?
And I don't think our letterhead has,
Printed?
Yeah.
It's,
Oh, you print it as you go?
yeah, so we just update that in-house.
That's what I do. Yeah, so just in-house, so it would be nothing, right?
Yeah, I mean, we would just update the logo that we have for our templates as far as on the letterhead, and we go from
I
there.
don't really does print it, I don't.
Who helped with the design? Did the
This
state
is
already approve it?
Yeah, it's all 15 came from the state.
Okay.
Thank you.
Publications.
Okay, any other questions or comments? So,
Did you do public comment?
they already
Okay.
declined.
Okay, Dr. Tretzky.
Aye.
Ms. Michelin, aye. Dr. Twala. Ms. Garcia.
Aye.
Dr. Calbucci.
Aye.
Dr. McIntyre.
Aye.
Mr. Mardani.
Aye.
Dr. Wong.
Aye.
Ms. Bramley.
Aye.
Motion carries.
Great.
Wow.
Yeah, it's just updated and it reflects how we're growing and evolving.
So you can post that on Facebook.
Sure.
So, you know.
Yeah, I'm just updating the profile picture
If
of
you have
our.
an email, you can start a new logo.
Doesn't matter,
Yeah, look at that.
doesn't matter if Rob comes across, a stack of envelopes or something with the old logo. It can be used.
Yeah.
Okay.
Okay.
So I'll let publications know ASAP, they're asking about it, so.
Anything else from that?
That was it.
Okay.
Oh, the newsletter.
Oh! Alright.
It was approved.
Yeah. And it was submitted to the publications team, and it looks like it's gonna get released at the end of this month.
Wait a second.
Go right ahead.
So I'm looking at this and it's great that we're publishing the citation and disciplinary decisions. I don't know if we've done this in the past, I think we have, other boards do this, but I have a concern. And that concern relates to the section on accusations, pending accusations. Let me finish my statement with some questions. Do other boards publish pending accusations? I am concerned that an accusation is only that, it's just an accusation of wrongdoing or violation, not a finding by this board that it's only an accusation and that the person's entitled to a hearing and evidence and the board has the burden of proof. So I am a little concerned that accusations are being publicized in our newsletter without any of the kind of, without any, A, that they're published, B, that without any kind of explanation of what an accusation is. I'm also concerned that in the way they are presented, it's presented, the order in which it's presented in the newsletter, you see that cite and fine is the first one, then pending accusations is the second one, and the third one is probation, so, and then statement of issues. So I guess my thinking goes in statement of issues and accusations, and the fourth one is surrendered. So by the mere order, it creates an equivalence of these accusations and statement of issues with surrender of the license and citing the fine. So I'm concerned about how that looks going to go.
So you're looking to order it just differently. It looks like it's alphabetical as far as the titles go,
Okay,
from what I can see.
I feel that's a little unfair. What do other boards do? Do they publish pending accusations and, okay, and do other boards put a statement saying, you know, it's not a finding of the board that they committed any wrongdoing, but, you know, something to show that,
It's still pending.
yes, that what's clearly pending and there's been no finding by the board that any wrongdoing has happened.
Well, I think I know this one board, the Bureau of Private Post, has an explanation of what each of these accusations means, a written statement of charges filed against. So there could be a explanation of what these mean, cite and fine, what is accusation at the beginning.
So I think we should consider that and also change the order.
Isn't it? However, it is a public record, the accusation.
We're required to-
I get it, I get it's a public record, but it's,
And it's a requirement, right?
That was the question, it's like if you look at my license and there's an accusation, it says, there's one there, it says that this is just an accusation, so.
yeah, fair enough, but it's not on here, right? It's not on the newsletter.
Didn't we do this last time though? We published it this way in the last newsletter.
I missed it.
And that's fine, I mean, it's always good to come back
Sure.
to concerns, and I don't think it's too late to
Reorder,
I
add.
consider it.
I-
Before.
am not sure, I can try and contact them.
Would you be comfortable if we let it go this way for now, since we did it last time, but going forward, we change it in the next newsletter?
So do whatever you can do.
Okay, I'll
Or at
contact
least
them.
maybe add a little mini explanation of what each one of those are, like at the very bottom of the newsletter.
I think the point is though, if whether it's too late.
It's
to
too late.
process
Yeah,
this
exactly.
one, but for this next one, I don't think.
So I think the fall newsletter, we just note that we need to change it to what Mark suggested.
Reorder it and then have
And then just.
an outline, a little
Yeah,
blurb.
like a little box.
But, yeah.
Thank you. Dr. Chawla, practice in ed.
So, most of it is pretty straightforward. The two things that we did vote on last time, we voted against recommending a regulatory change to allow optometrists that are teaching or presenting classes to dispensing opticians to get credit CE. We voted against that. And the primary reason is it doesn't fit in the regulations. It doesn't match what we actually have on file as law. But we didn't think it was appropriate, actually. We didn't think that it actually, the definition of what continuing education should be in terms of like contributing to our advancement in the profession, we just didn't think it fit. So we voted against that. The second topic was, do we want to increase the number of online CE hours? And, you know, if you look at the memo that's attached here, we're right there with what, you know, we're a little bit higher even than some states. So we looked at what we thought was appropriate. We didn't actually agree with, you know, there's the advantages to online CE versus disadvantages. We didn't agree that the disadvantages are none, you know, so we talked about that. We talked about, you know, you can step away from a computer. People will see throwaway journals where somebody has filled out something and just they can copy it. You know, it does happen. So we didn't agree that letting every course just be online or through a throwaway journal was appropriate. We went back and forth. There was a discussion of no increase at all versus just increasing slightly, and we went with the, you know, increasing it to 25 would be the recommendation, and that's what we would ask the board to start taking action in that direction. That was our recommendation.
The other large state optometry boards, where do we, if I look on the next page, so I recall New York was large, right? That had the most
I think she means by large
size
of
Yeah, to make
people.
sure that or to see if we're at least comparable, if not a higher standard than by the number of optometrists in the state.
Well, Texas is a large state, for example, and we're below, you know, so we increased slightly to, actually their percentage is right around 50. So 25 brings us to 50.
So that takes us up a bit more.
You know, so we just didn't think it was appropriate. We didn't really, I mean, New York does less
Right.
percentage-wise. So we didn't, you know, the question really was, we actually talked in great detail about not increasing at all, you know. And then we thought, well, you know, a few more is not the end of the world, and it does provide a little bit more convenience. So we didn't think there was harm in going up by just a bit. Dr. McIntyre, Dr. Wong, if you guys want to talk about, you had some concerns about increasing very much at all for the online CE, if you want to.
And then goes back to what you said in the beginning, is if somebody's online, who's to say they're not walking away, making dinner for the kids, walking the dog, and yeah, it's gonna happen. And I really like the idea of, you know, in person CE, but that's not practical with technology nowadays. We have to kind of move into that a little bit more. I just don't think we need to make big giant leaps.
And actually, one other thing I do notice about lectures, I tend to go to most of the ones from either COA or COPE approved, like Review of Optometry has quite a few. And I really, and I've gone to some small ones, you know, in different states that also have COPE approved. They're really good, actually, about you can't just walk away, they won't let you sign out early, you know, so there's a lot of things that they put in place
There's a lot
to
of
ensure, like monitoring that you actually are participating in the CE. That's not there online, you know, so
But, you know, at the same time, online CE, the quality of it has improved
that's improved
significantly.
too.
And then we're entering the age of technology, so, I mean, there's pros and cons for both. Allowing people, especially doctors who are in more rural areas where it's a little bit harder for them to get access to in-person CE, maybe a few more hours just makes it a little bit more convenient. But there's no denying that sort of in-person CE. We all felt that there's really a need for people to actually go in person to attend certain education courses. So this is a nice compromise.
What is your baseline goal or rationale for increasing CEs? Is it related to, what was
Increasing
your
the
driver?
online?
Just the driver for
We're
increasing.
trying to be fair in terms of just like what Dr. Wong just said, just a little bit more convenience for, you know, maybe somebody can't get out to do it. It provides just a little bit more. But
these options and alternatives.
Yeah, and like I said, I mean, the quality of online CE compared to what it was 10 years ago is significantly better now. So there are a lot of other, I don't know, vendors or people or schools that are providing a lot of online CE that they weren't doing before. So I just think the quality of the CE is so much better now that you can definitely get something out of the articles that you're reading online. Whereas 10 years ago, not that many people were doing as much online CE. So it's better CE.
Okay, the school was the schools were a big thing for me. I just did a thing for not this license renewal, but the one before it, where New England put out a whole thing about like glaucoma certification. It was really good. It was like a 6-piece kind of progressive, I won't say, I mean like a series, kind of like a 6-piece progressive article series where it started with like basic and went quite a bit into the different aspects. And I thought it was really, really good. STCO's online CEs have gotten so much better. I think schools are investing in that, and that was kind of a good reason to go up a little bit.
Didn't we feel that if online CE was more interactive, we would be more apt to increase the number of online hours we allow? But how do you control that?
Right, that was something to be seen like in the future, right?
But so if you've got people sitting there on the computer and they've got a response that they have to keep giving, but CEs aren't set up like that now online, but perhaps in the future.
That was for like not going all the way or much higher, you know, so we felt there was a different value to the classroom setting, so.
Actually, you just raised a point, one of the 2 points that I was going to make, that is, I know when I create a CE for my employer, and I want to make sure people are not going off and making dinner, is to require them to answer questions throughout. And so I'm glad that the committee, which I can't remember when I was in, but I missed this meeting, thought about that, and I think that's a requirement before we start considering greater amounts of online CE. The other question I have for the staff is, I know we monitor and audit CE by our licensees. Does having online CE, sometimes from other states, does it make auditing easier, more difficult, or irrelevant?
I don't think it's come up as an issue. I know with the people who are doing the audits and organizing it, they haven't brought it to my attention and said that something's going on with the online courses that are offered out of state. We need to address it. I think usually when there's something that comes up as an issue, sometimes we brought it to the PEC and it's something to consider. But as far as the audits go, they've been pretty straightforward. It's just, as I was talking about earlier, I think there's a lot that goes into it. We want to make sure we do it correctly.
It's the same, either you upload a certificate, right, you send them the certificates, or if you have like a tracker mechanism, you can print that out for them as well. So, because you can upload those things to, if there's like like the OE tracker, if we do it through Breeze or whatever, so it's the same way of documenting them, because you still have to get a printed certificate by such and such school, because here's the credentials of the person who's doing it, and they're, all of that is already there. So it shouldn't be too different.
Any other, yes?
So, do we have to vote to adopt 25 versus 20? And then does this require that we get hooked up to some bill somewhere to change it in statute?
Right. Yeah, it's a regulatory change.
It's regulatory, not statute. Oh, cool.
So we can, it's kind of here that the recommendation is written is that we recommend that the full board direct the staff. At first, I mean, we can do it in 2 different ways. I don't know if we need to say, okay, first we want to go from 20 to 25, or this particular recommendation is all inclusive. How it's written, I don't know what anyone thinks.
I think you'd be directing board staff to actually begin the package for the regulation, bring the text back to you, and you adopt the text of the change.
So we'll need a motion since we're directing staff.
So moved.
Second? Second. Thank you. Further discussion from the board, from the public?
Dr. Turetsky.
Aye.
Ms. Michelin, aye. Dr. Chawla. Aye. Ms. Garcia. Aye. Dr. Capucci.
Aye.
Dr. McIntyre.
Aye.
Mr. Muradami.
Aye.
Dr. Wong.
Aye.
votes for aye. Motion carries.
Ledger Reg,
Sorry. So Ledge Reg, number one is mobile clinics. We continue to talk about the mobile clinic issue. Again, we've had a discussion before that this is a very big bite of the apple to take it all at one time. So our recommendation to the full board is to move forward with pursuing homebound legislation that the board, I believe we approved the language at the last board meeting for the next legislative session, which starts in 2019. And then asking the board president to appoint a two-person work group who will have the responsibility of finding an author for the bill. Those folks can start shopping for an author anytime after the first Monday in December, when the new legislature is sworn in. So that is the first item on the table, if we would like to move forward with that. Oh, and then just to back up, we will continue discussions around the full issue of mobile clinic, but given that we don't know when we'll have an executive officer, that type of thing, figured the homebound, let's at least get that piece of it done, and then move forward at a later date with the other issues pertaining to mobile clinics. So I'm looking for a motion.
any discussion on the topic to begin with? Ms. Morgan?
So I want to make a statement, it's not a question, so no one's able to respond.
But we can if you want.
But we can't, don't respond to Mark's comments.
No need to answer my question, but it's great that the committee has proposed to move this forward. I want to say that, looking at the law, I'm not sure that the statutes say that mobile clinics are prohibited. I know there's some interpretations out there, but I'm not yet convinced that the statute says that mobile clinics are prohibited. It doesn't say that in black and white expressly. So as we move forward on this, I'd like to make sure that as staff helps with the language and works with the authors, that we don't concede that the law says that mobile clinics in general are prohibited, and maybe that this seeks a clarification of perhaps ambiguity or of the law to make sure that at least with homebound visits, that it's clear that they are permitted. So it's a bit of a nuance, but I don't want to foreclose our ability to maybe drill down or revisit the idea of whether the law prohibits mobile clinics.
And what Mark's referring to, and I agree with, is that part of the decision around homebound, correct me if I'm wrong, Nina, is that the last information we have when the state dealt with this issue was under Attorney General Brown, number one, the father of our current governor. And that came down in 1954, or all I know is there were no televisions really, there were no, that's the last time the state has actually addressed this issue.
And the law was slightly different.
And the law is slightly different. So I agree that, and I don't know if there's an opportunity for us to go back to the Attorney General's office in light of technology. I mean, at that point, whoever thought we'd be sitting in a meeting with all of our computers and cell phones and all of that. I don't know, can we ask the Attorney General's office now to reevaluate that? How does that, I don't know how that works.
I'm not familiar with that, but I will find out for you and let you know.
So maybe considering that we can't even do anything in terms of legislation until December, I would suggest that we, at our next board meeting in November, we look at whether or not we need legislation, so maybe we postpone this motion and bring it back in November, get a report and see if we, to your point, need legislation at all, and then make a decision from there.
Get the opinion in writing.
Is that,
I would prefer to move forward with the homebound now
And investigate it at the same time.
well, we
and
can't,
investigate, yes, and then have the, this Rachel's idea in our hip pocket and ready to go. But I wouldn't want to wait.
well, it doesn't matter, because even if you can't do anything with this until January anyway.
Well, with the homebound though, there are certain laws that are in place currently that would make it much more difficult to practice homebound care. So I think that we still need to move that forward from a pre-legislative standpoint. But the mobile part is the part I think that we can still get the information and the.
But even on the homebound care, just so we're all on the same page, that's legislation. We can't do, we're saying we need to introduce a bill. We can't even entertain introducing a bill until December, even on the homebound, because we're not about to go and shop and amend, and no, we're not gonna do that. So my point being, the timeline, even if we can vote on the homebound now, but just so everyone knows, that still can't happen until December. We have a board meeting in November, so we could do it either way. I just want everyone to understand that even if we did this, there's still a wait time of December before you can shop a bill. Because, you have an election, you have all kinds of stuff going on, so that's just my, either way, it doesn't matter to me.
So maybe we could vote today, knowing that nothing's going to happen until December, and at the same time, direct legal or ask legal to investigate and see, investigate Rachel's idea.
I'll move.
I'll second it.
I'm sorry, so let's clarify that. So there was a recommendation to appoint the two-person member group to ask President Grandvine to do that. Is that off the table?
No. So the motion is to take the recommendation. We've already, and I believe we approved the language. So now we're asking the motion, correct me if I'm wrong, is for the board to give the president the authority to appoint a two-person work group, who then will go and find an author, which is in December, because you can't go until December. And so then that two-person work group though would also be tasked with lobbying the bill on behalf of the board.
With what though?
The homebound mobile clinic.
Combined.
No, separate.
Keeping them
We're keeping them separate. We're not taking on for-profit mobile
And
clinic.
there is complete wording
For
or language
homebound.
for homebound.
Correct, which we approved at the last board meeting.
Right, okay, good, okay.
So that's done. All we need now is a two-person work group on that piece to shop for an author and then lobby the bill.
And then I understand my
And then
direction.
Nina then is directed to research, to Mark's point, do we even need it? So then by the time we come back in November, hopefully we will have some clarification and maybe Mark's correct and we don't need it. So, but at least we'll have information.
So to direct staff and legal counsel. Okay, so that would need a motion in and of itself.
So, on that second point,
Yes.
I will guarantee you that Nina's not gonna come back and say Mark is correct. I understand, it's just because of the
Complexity.
the fluidity, and you get two lawyers in the room who have 5 opinions, okay? And it's.
But I understood the direction also to see if there's a process to get a more formal opinion from the Attorney General.
It's a little bit more up to date.
I don't know if Ms. Crawford could
She's
speak to that. Do you know the process for asking for an attorney, a formal opinion, AG opinion?
I'll look into that.
Okay, and I can,
Right, so.
I don't know if that's where you were going with it.
Well, I think we should have a discussion as to the options, perhaps. I don't know if I want to commit to getting an opinion or not. you know, that I need to hear what the processes are and figure out exactly whether it's a good idea or not, particularly in the context of what we want to do legislatively.
So I would recommend that your motion be limited to having President Van might appoint the two-member person to move forward with the homebound. And I understand the direction is to come back with information about the process, the different options you have. You can have a legal opinion from me, you can have the process to get a legal opinion from the Attorney General's office, and then you decide in November how to handle that.
Great.
That's my recommendation. So I think someone made the motion.
Lillian.
Oh, Mark made it, I second.
Oh.
Okay, discussion, other comments, public discussion, comments? Yes?
So while, Crawford, Deputy Attorney General, so while we're gonna look into that issue, the question is, I'm trying to narrow down the question of what it is you would like an opinion on, with the understanding that the question may not be taken up for an opinion, and that if it is, those opinions are generally public and published.
Got it.
And I can talk to you more about how to phrase the wording of the request. I know they want very specific, but it's basically our mobile units, mobile clinic, mobile practice, permissible under the current statutes.
Well, maybe. I think we need to work,
Okay, we can
work to craft the question carefully and perhaps do research on our own before we present the question to the Attorney General's office. I think at this point we want to understand the various options and procedures that exist, and then we can decide how to phrase the question.
Then you have
Process.
12, you have 12 opinions between three of you. You've got some more opinions to go.
That's public comment. You can introduce yourself.
Catherine Scott, I stand with Purpose. I just wanted to agree with, and just from a different,
Which I can never do.
the
Are you an attorney?
the published part. So, I've seen lots of AG questions, and they're published on the AG website, and they're taken as legal opinions. So if in fact, there's a gray space here, you might just want to make sure that the providers who might believe the law allows them to do it, knows that a question might be posed that could decide that they can't do it, and then you have a rather urgent legislative issue on your hands. So just a point of perspective.
As a matter of law, I want to step into, I'll try not to step in his shoes, but Attorney General opinions are only opinions.
Yes, they're not precedent that a court would necessarily.
Right. A court will give an Attorney General opinion great weight because the Attorney General has studied it, but they are not the law. So, just
And ultimately, if I gave you an opinion, it would be what I believe a court would likely find is the correct interpretation of the law, which is what the Attorney General does too. But
As somebody who isn't an attorney, let me just say that when attorneys do this, because we have this question come before the board a lot, when you do this, the practitioner thinks it's the law. Because
the legal opinion from counsel
or
or
well,
the Attorney General.
either way, because they come to you for advice, you are the professional. So when you give an opinion, when I ask you a question in the context of the board and you say this is my opinion, I'm not going to go against it. I mean, it would be kind of rare for me to say no.
And that's, I think, why we want to be very careful.
That's what I'm
with
saying.
law.
So I'm just saying from the other perspective, yes, it's theory, no, it's not law, but the people that you are talking to and what Catherine Scott is probably alluding to is that people are going to see that and go, oh, that's the law, because the Attorney General said so. And I don't know, I'm just saying, that's what the practitioner would do. If I was in those shoes, I would want to tread cautiously if I was doing that, because now somebody who has authority, highest authority in this particular state, has rendered an opinion whether it is actual law, it's the actual law of the state or not. So,
well, not necessarily the highest authority.
well,
A high authority.
yeah, a very high authority in the state, right? So, but that what you're talking about is theory. I'm telling you in practice, and this is what will happen.
So I need to clarify the motion. So then, is the motion, so is your motion saying that we're going to look into how we would formulate an opinion AG's office?
No, we're gonna find out.
Are we
I
gonna
think my
actually
understanding
ask
was,
for it?
I don't think you need that as a motion, I understand
We should
that.
just do this 2
The motion is on the two-person work group to shop the language for homebound care to the legislature in December.
I think that's it.
That's it.
That's it.
Okay, all right. This other thing is just really.
That's been seconded, right?
It's been seconded.
Okay.
It's
Okay,
been
and no more discussion and no public input on that particular motion.
Dr. Turetsky.
Aye.
Ms. Michelin, aye. Dr. Chawla.
Aye.
Ms. Garcia.
Aye.
Dr. Calcucci.
Aye.
Dr. McIntyre.
Aye.
Mr. Mordomi.
Aye.
Dr. Wong.
Aye.
Ms. Graham.
Aye, and I'll get back to this group with the two-person working.
Motion carries. Then the next item is pending legislation. We updated by staff on bills that they're monitoring. The one bill is the branch licensing, Senator McGuire's bill, SB 1386. The committee is recommending we continue our support of that bill. Make sure we put in a letter of support. I don't know if the letter has actually been submitted. Do we know? Does the author have a letter of support?
Not the second one, I think they got the original one.
Okay, and then the other piece of that would be then to also have a motion, should the bill pass, that then we submit a letter of support to the governor's office for him to sign the legislation. The other piece of legislation, you know what, let me stop there, because the next one is the licensing, AB 2138. So let's knock out 1386.
Do a motion for that.
Do a motion. So I would entertain a motion to continue the board support of SB 1386, and then to also direct staff to submit a letter of support should the bill pass the legislature and get to the governor's desk, that we send a letter of support to the governor's office in support of 1386.
I so move.
Second?
So I have a point of, if it changes though, are we just offering up now our motion? Is it possible it's gonna change? It's not.
I doubt it, but typically if it substantially changes and it is amended, then we can pull our, we can pull the letter of support. But the only other option is support if you don't do, it's either support if it's amended, which we don't want it to be amended, or oppose, or don't take a position.
So
We
I-
currently have a letter of support in, we're currently
Right,
supporting
right,
it.
with, that was with the version at the time, so I just want to clarify the motion is for the bill as written right now, these are the things that we want.
And I don't believe the bill's changed from the last time that we had a vote on to support it, correct?
I'm trying to remember what the version was when the full board, when the full board asked for the support, submitted their support officially. That was before they had taken out the language regarding professional conduct and reporting by nature. Right now, as the bill stands, it's basically just the cap on the office limit on
We had that discussion on the call, when we did the special call about that issue. And we voted to still support the bill.
Yeah.
So it was on the conference call, it wasn't the
Conference
full
call, okay.
board meeting, it was on the conference call we had. The board call, full board conference call. So that's,
Okay, so I have a motion on the
I
floor.
don't know if it was the full board conference call.
Or was it the LRC?
no, when we got the
No, there was a conference call.
The LRC meeting, it was to continue support because it hadn't changed since we voted and had the discussion
On
on the full board, on the special meeting on the conference call.
So I'm just asking for a friendly amendment that we clarify that it's for as currently written. That way, if things substantially change, we clearly will need to come back as a board to decide if we're going to continue to support. Right now, the motion I feel is a little vague, so I just want to make sure that we're clear on that aspect.
I'm just really blunt, you're going into the end of session, it's the craziest time. We will not have time to have another call, to have another discussion on the bill. So we either have to support it or just don't take a position on it, because we just won't, it will be hard to do that. Because it's just a crazy time.
And the only part though is about the number that remains.
Right, they took out all the other stuff.
Yes, and COA, correct me if I'm wrong, Dr. Tredsky, COA supports it now too, or they don't,
COA
they
is
don't.
neutral. They've gone from opposed unless amended to neutral.
So, I'm not a member of the legislature, but I would assume at this point, it's probably not gonna be significantly amended, because they've gotten agreements from all legislatures. And again, it's not our will, so it's still up to the author to do whatever he'd like to do with it.
And from what I've heard, none of the other stakeholders have any objections to what's going through right now. The big objection would have been COA, and with a neutral stance, there's no reason it shouldn't pass.
We have this discussion every time it gets to the close of the legislative session. I'm happy to delegate to the chair and the chair of the Legislative Committee if they need to make a judgment call and have the full authority to make the call on behalf of the board.
Okay, so we have a motion on the floor, we didn't get a second yet. We have what sounds like another motion on the floor. Do we want to swap the order of those motions, perhaps? Or proceed with one, we'll need to proceed with the other one.
I think we should just finish the first one.
Exactly, but this second one that came in,
I haven't made a motion, I just think that's. Why don't we vote on the first one and see where it goes?
I first need a second on it.
I'll second.
Okay, thank you. Any further discussion by the board? Public? That would be no. Okay.
Sorry, I'm just reading, is it in suspense? Is that what it is? Is it a suspense file?
No, it's in the appropriation, I think it's always, yeah, it's got a hearing next week.
Suspense?
I think that's a vote of suspense, but it's
Appropriation.
pause, it's an appropriation. Hearing in the next 2 weeks,
Okay, starting next week, right?
Monday.
Okay.
Yeah, 15 and 16, I think it's next Wednesday.
Alright, hold on, sorry. I forgot to mention. Okay, Dr. Tredsky.
Aye.
Ms. Michelin, aye. Dr. Chawla. Ms. Garcia. Aye. Dr. Calhoun.
Abstain.
Dr. McIntyre. Aye. Mr. Morinami.
Aye.
Dr. Wong.
Aye.
Ms. Randall. Aye. Motion carries. Okay. And then are we doing that?
I don't know.
Well, I will ask the chair of the Legislative Committee, do you need that motion to feel comfortable about what's might happen, or if not, I will make the motion.
I mean, we have this conversation every time.
Yeah.
It's like, from the beginning of like, what? It's always like, do you want to give one person authority to speak for the board? And it's always kind of tricky. And we go in a circle, and the legal counsel says, well, same thing, do you really want to do that? So, I don't know that we need to do that. This isn't even our bill.
Yeah, I mean, I think at this point, part of it is you take a leap of faith and, you can only do what you can do. I mean, they can decide at the end of the day, in the last day of session, at, very last bill to strip this bill of everything and make it something else, and you can't control it. I mean, so either we, and quite frankly, it's a bill pertaining specifically to branch licenses for optometrists. I think the perception that the board isn't even involved in it, it doesn't even take a position, makes us look, I think it's better to just take a position and move forward.
Okay.
I
will make a motion.
I don't think we vetted it. I think that if anyone has a question, they can look at all the webcasts. We've had numerous conversations, we've had public comment, we had a work group on it. At some point, we just have to move forward with it. Is that it? Okay. So then, continue to oppose AB 2138. This is the bill we talked about before. Were you going to talk about it? Is this the one?
I think you talked
Is
about,
the other one.
this is the one that we talked about at length, and I think Mr. Morton spoke
So this is the bill that,
earlier today
yeah.
about the, taking away discretion from the board
Yes.
to deny licenses and based on criminal convictions unless they happen within, originally it said 7 years, and they had to be for violent felonies. It's now been amended to proceeding, I'm sorry, for originally it said 5 years, now it's 7 years, and it's changed to serious felonies, and another amendment of some language substantially related to the qualifications instead of directly and adversely. I still think a lot of the same discussions you had, implications and policy discussions you have are still existent in this, and I believe the committee felt the same way. So the recommendation was to continue to oppose it.
so most of the other regulatory DCA boards, such as, I'm trying to find the whole list, Medical Board, Board of Accountancy, they are all opposed to this bill. I think some of the discussions is also, it does take away, it does take away our ability, like what we did today, in terms of making those decisions. I think that we're tasked with consumer protection. So I would entertain a motion that we continue our opposition to this legislation, and should the bill pass the legislature and get to the desk of the governor, we also submit a letter asking the governor to veto the bill.
Do you have a second? Second. Further discussion from the board members? No, public? Okay.
Okay.
For the vote.
Dr. Turetsky.
Aye.
Ms. Michelin, aye. Dr. Chawla. Ms. Garcia.
Aye.
Dr. Calgucci.
Aye.
Dr. McIntyre.
Aye.
Mr. Morani.
I'm abstaining.
Dr. Long.
Aye.
And Ms. Brandon.
Aye.
Okay, then the last bill is, we do not have a position currently on AB 2461. This was the issue that was with the FBI, which you talked about earlier with the FBI rap sheet, that it currently stipulates that the medical board and I think the other board, they're in the bill specifically, so that the suggestion by Jessica in her report was that we contact the author, say we will take support if amended, and that they amend us specifically into the legislation. So I personally think that's probably a good idea. And just to read it, what it says just at the very beginning, if you have, the Department of Justice shall provide to the State Department of Social Services, the Medical Board of California, the Osteopathic Medical Board of California, pursuant to state or federal law authorizing those departments to receive state or federal summary criminal history information, and may provide to any other entity authorized by the state or federal law to receive state or federal summary criminal history information. So I don't know the history on how the medical board and the other board got specifically mentioned. I don't know if you know, but hell, we might as well have our name in there too. So
I'm surprised, honestly, because Jessica's been working on this for
Yeah.
a long, she had been working on it for a long time, so.
yeah, so it may require someone from staff to go and actually meet with the legislative offices and do a little lobbying to get us in there. But I think it would be important that we try to get in there. It sounds to me that we probably would, they might come back and say you are, because it says to any entity authorized by state or federal law. I don't know if that would.
No, I think you want.
We have
to have the
specific?
yeah.
So the recommendation.
That's an authorization, but not a requirement.
Okay. So my recommendation would be to take support if amended, as long as they amend in that we are specifically mentioned. And should they take up that amendment and the bill passes the state legislature and goes to the governor's desk, we also submit a letter to the governor's office in support of the legislation. And currently this bill is in Senate appropriations. It's being heard on the 6th, which is what, Monday? And if you look at the vote history, it's a pretty bipartisan bill. So, you know, there's a good chance that it will pass, so hopefully we can get our name
I think your first part was the motion.
Yes.
Yeah, but I wasn't motion, can I make the motion, or someone else can make the motion? Sure. So I did what I said before.
Do I have a second?
I'll second.
Any further discussion by the board, public? Roll call.
Dr. Tretzky. Aye. Ms. Michelin? Oh, that's me. Ms. Garcia? Aye. Dr. Koguchi?
Aye.
Dr. McIntyre?
Aye.
Mr. McDonald?
Aye.
Dr. Long?
Aye.
And Ms. Bradley?
Aye.
I motion to take a break.
No, he's thinking of more, so that's fine. I think I'm done.
Thank you. Before we,
She's all thank you.
no, not that kind. Before we get into dispensing opticians, I do think we take just a quick 5-minute break. You think
Please.
to run down the hall, and then if folks can come back pretty quickly, I would appreciate, because we are trying to expedite. Thank you.
That's okay, I was hoping Chris would leave.
All right, we're back from break, and we're resuming with agenda item number 8E, Dispensing Optician Committee Report.
Okay,
Ms. Garcia.
when we met yesterday, and the very first thing we talked about was, after meeting with the American Board of Opticianry, we talked in April about them getting a letter out to all the opticians who are currently taking their exam, or took their exam in May, because a lot of the opticians are a little confused whether they're registered with the state of California, or just by passing the exam, that means they're registered and they're ready to practice. That letter clearly explains to them, congratulations, you've passed, but now you've got to further look into registering with the state of California through the Board of Optometry. I understood it also had our letterhead, and the staff, Rob did explain that the American Board of Opticianry established a good relationship, and that's going to be every time anyone passes that exam. So at least there'll be less confusion with those opticians, so they get registered. We went into the disciplinary guidelines. That took almost 4 hours of going and reviewing. We cut and pasted and moved a lot of paragraphs, because that we got from the optometrist, which a lot did not apply to the SLDs and the CLDs. So we took a lot of time to discuss page by page and went through everything. In November, we plan to meet before a board meeting and a review to see how that draft looks. It was, I thought we were very productive. At the end, we just briefly touched on, and we were talking to Rob about the occupational analysis. As you know, in discussion in April, we're talking about whether the exams are testing for what the opticians are practicing in California. And so once we get that occupational analysis, that's going to clearly tell us what and how we should be testing here in California, because they're not all practicing what that exam is testing on. So that's just sort of a question up in the air right now. So other than that, I think we're making progress. Believe it or not, we have 10 items on our list, and we're just barely on the first couple of items.
Okay, thank you. Any questions, comments, Dr. Calhoun?
So I know from a logistical standpoint, Ruby, that the committee meets the day before our board meeting. So the ability for the committee to bring back an electronic document for us to look at or to have for notes for the very next day would be a challenge. But is that at all any possibility?
We did have an agenda. I don't know why it's not posted here, but.
Well, not the agenda. I'm talking about once you have an
Yes,
agenda
once we
and
have
you
that.
discuss it,
Right.
Minutes.
The
minutes
right,
or a summary
of what.
of what was discussed and decided upon as a committee.
that would depend on staff whether they can get it done for us that quickly. I mean, it's really cutting it too close.
Well, I think, for example, the edits that were being presented yesterday were being input by Rob, and theoretically, if there was a vote to recommend that it be brought to the board to adopt, we could have had it ready for you, but that vote never happened because we're still working on it. So I guess it depends on.
Does that bill need a 10-day review period? Since it would be.
It would have to be pre-thought of to be put in the agenda as part. You could always take action on items in the agenda. So even the committee reporting, part of her reporting would be, we did this yesterday, and we'd like you to take action. So that would be covered under that agenda item.
Because the reason I bring it up is because as we get into more substantial topics, I really feel a need to be able to have the opinion of the committee, and for myself to be able to review it, think about it with time. So if you start bringing things to us the very next day, and that's the first we're hearing of it at a full board meeting, I'm going to be uncomfortable making decisions on it. So I'm just thinking ahead, not necessarily about your summary today, but I'm kind of thinking ahead for the future.
I agree with you. I think it would be good if we met maybe a month before as the other committees meet, and then we have a summary of what we discussed and maybe bring some proposals to the board. I think that would be a great idea. But we do need time. From one day to the next, it's impossible, I think.
Okay, so if you could
We'll talk
revisit your committee meeting schedule based on
this. Okay, and
Because that'll mean more cost sometimes,
Right.
staff support, things like that. So I'm not sure it'll be necessary for all the committee meetings, so maybe something that you can coordinate with staff on when you feel that it is going to be important, that there's time to create a summary, to allow the full board to see information ahead of time, so that when we have the full board meeting, we're able to discuss what you can do.
I agree.
Well, the other comment is if you have staff, unless we have a standing topic or, where we are allowed to review and vote on it, because you have to get it onto our agenda. Right, so
And
something
I just
comes
think
out.
an update wouldn't be sufficient to adopt
Yeah.
disciplinary guidelines.
Right, so you're not gonna, so whatever works, so long as either you realize in that committee that if you bring something forward and it's urgent, it probably can't be put on the agenda for the meeting the next day. So it's not gonna happen like that quickly. And I agree, because it's what we were talking about, it's like from the ground up. So, it requires some time and some consideration as opposed to, well, yes, so.
Well, I will work with you about the calendar, and we'll get that done soon, the next time around.
Thank you. Any other comments or questions for the committee? All right, so now we'll move back up to consumer protection.
Okay, thank you. As I indicated earlier, we're not going to be able to come to a decision on the updates to the disciplinary guidelines, but I'd like to take the time today to introduce the topic to all of you. With the help of staff, I have kind of 3 sets of questions that will help us walk through and understand what the disciplinary guidelines are, and then I will have a little homework assignment for each of the board members at the end of this introduction.
Yay, Mark.
So,
Mark, do you mind if invite Ms. Crawford?
I was going to say, I'd like to invite enforcement staff and
Does she get homework too?
the attorney general.
They get homework?
That's only fair.
So, when this document first arrived in our committee, I was a bit overwhelmed by the document and didn't really know or comprehend what it was. So I imagine all of you have that same reaction as this is coming to the board for the first time. So could staff explain to us in the context of the Board of Optometry world that we live in, what the disciplinary guidelines are, and staff and the Attorney General representative can explain to us, who uses these guidelines, and how are they used by enforcement staff, how are they used by the Attorney General's office, how are they used by administrative law judges, and how are they used by respondents. So let's start with that, yes.
So, Disciplinary Guidelines is a book that is adopted into regulations. It is, just like it says, it's a guideline for disciplinary terms for respondents in our cases. It's used by us and enforcement staff to offer settlement terms, to make determinations if a case should go to hearing or if we should settle. It's used by the Attorney General's office to help us draft those draft settlement papers, or to present to an administrative law judge to make a proposed decision. So it's used for cases where there is a violation of the law that we feel that we're able to prove, and that rises to a level where something more than an educational letter or even a citation would be appropriate, where we're actually filing an accusation or a statement of issues against a respondent, either seeking to deny a license or revoke a license. And it provides guidance as far as, depending on the violation that we're alleging happened, what the discipline for that should be and should look like.
So from the prosecution standpoint, once that case gets to us, we use the statutes and regulations to file the accusations. We use the disciplinary guidelines to dispose of that accusation or the statement of issues. So this is our dispositive material. It's what tells us what to do with the case once an action has been brought. And the AG's office uses it to make sure that whatever the statutory violation is, that if there's a settlement term, that settlement term comes from the disciplinary guidelines where it says this is what we're looking at for maximum discipline for this violation, this is what we'd look at for minimum discipline. In letters that you get with stipulations, the DAG has to write a letter recommending adoption. And we look at the disciplinary guidelines to provide guidance to you that these are the violations and this is the stipulated settlement, and it's in line with what the disciplinary guidelines are suggesting should be the stipulation. Now, if we're going to deviate from that for whatever reason, then that needs to be explained because this is the standard. So if we're going to go harsher or more lenient, there needs to be an explanation to the board why there's a deviation from the guidelines that the board has adopted. And the ALJs likewise use it in the same manner. Once they hear the case, we don't really argue what the disposition should be, other than we always generally seek revocation. If we're going to seek probation, we might give them a few hints of some of the key points we would like them to have in the probation terms. But for the most part, they review this themselves in every case, and they're the ones that go through it and put in the terms. So it's pretty critical that the guidelines be very clear and provide the guidance that the ALJs need to see, because they can't reach out to anybody and say, I don't understand this. So we have received some decisions from ALJs that have been pretty clear that they didn't understand what was required from the disciplinary guidelines.
And how do respondents use this?
So during settlement, I know it's my general practice, and I think it's probably the practice of many DAGs, that we provide them with the disciplinary guidelines and say, here is, because we can't advocate for them, especially if they're pro per, we usually say, take a look at this, you've got the accusation with the charges, this is what you'd likely be looking at if this matter settles, and then it also gives them exactly what their terms of probation would be if the board decides that they're going to settle with that respondent. So it gives them a whole lot of advice. Some boards actually mandate that they be served with every accusation and statement of issues, so that the respondent immediately knows what's expected of them. There's also usually a page that the boards devote to information that the board would want to see if that person wants to engage in settlement discussions. So there'll be an entire page of send us a letter of explanation and any work performance evaluations, letters from colleagues, so that they're immediately kind of put on notice of if you'd like to entertain settlement, it doesn't just come without any kind of participation on their part. They're given exactly what they need to provide, and they're also given information in here, which I think is in this, of what are some mitigating factors that the board is going to look at in their case, and what are the aggravating factors. So if this is someone who has a criminal conviction, they'll see that the board is going to look at their overall history for criminal convictions, not just necessarily that particular one, in considering discipline. So it really provides a great deal of notice to the respondent of what to expect from the proceedings.
So my next set of questions are about the makeup of the document. And so if you look at the table of contents, I see 1, 2, 3, 4, 5 kind of major sections, starting with the introduction. Can one of you just briefly describe what each of these sections are about, just briefly? And then I'll dig a little bit deeper on the last section, the recommended discipline based on a violation. But if you just kind of briefly walk us through how this document is organized.
So the introduction section talks about the types of disciplinary and administrative actions that we can take. It also talks about the public record, which just lines out our policy that all of these items are public information. And then this disciplinary guidelines section is a little bit more information. It talks about, as Anki said, the evidence in aggravation or mitigation of discipline. So those items that we would need to look at. It gives information to administrative law judges. Then we move into the uniform standards related to substance abuse section, and that is related to the uniform standards. It gives information about that. The probationary terms.
The uniform standards, those are kind of imposed upon us by your statute, by the departments. Is that right?
Sort of. It was adopted by the department, but the board voted to align itself with those standards.
So these are standards when we have a substance abuse case.
Right. And then we get into probationary terms and conditions. That actually is the language of the terms. So if somebody's put on probation and one of their terms, the standard terms, number 2, that they have to file quarterly reports, this is the language that goes into that order, specifying that they have to do that and what the order itself is. The final section is the recommended discipline based on violation. So that's where we break out things like, the first one is excessive prescribing or treatment. It quotes the code sections that we would charge for that, and then it gives a maximum discipline, a minimum discipline, and then for the probation terms required and if warranted. So these are, if we charge that to a licensee and said this is what we believe you have violated, these are the conditions that we would expect to see in a probation term.
So why don't we jump to that? Because I think that's the actual meat of this disciplinary guideline. So, as you pointed out, that's page, at least in the committee report, page 38 of the committee report. I don't know if someone can help me and tell me what PDF page that is. But it's page 38 in the committee report, and it's the section recommended discipline based on violation. So let me express my understanding of how these disciplinary guidelines work, and then please correct me if I'm making a mistake. So it's page 35 of the PDF? Okay, thank you. So this section goes through every statutory section in the optometry code, every possible violation, right? And goes through the required discipline and if warranted discipline for every single violation. So it's quite extensive because it goes, there are lots of possible violations in our code. But so for example, let's take the first one, and that is the, am I all right so far?
I would just because I'm reading it here, but no attempt to say to us all possible violations, so I think you're generally correct though.
Okay.
Its intent was, but I don't know if anyone has gone through
Thank you.
and compared to the statute.
We've done our best.
Yes.
So just as a for example, let's take the first one on the page, excessive prescribing or treatment violation, right? So it cites the code section that would be violated. So if an optometrist has excessively prescribed, the possible maximum discipline is revocation cost recovery, right? That's the absolute maximum that we can seek or that the AG's office can seek.
And actually, I think this came up, and I'm sorry to interrupt you, but in the DOC meeting, that the cost recovery isn't really a discipline matter. It's more just it's a statutorily authorized ask.
We may need to fix
So
that.
maybe we need to fix that.
And we won't want to have it on there either because we won't be able to get cost recovery if it's a statement of issues.
Okay.
And just to kind of clarify, it's not the maximum that can be done, it's what we're considering the maximum discipline for this particular violation.
This particular
So it could be that we have a violation where we consider the maximum discipline to be a suspension versus outright revocation, if that makes sense.
depending on what the violation is. Right. But for this particular violation,
Exactly.
the maximum discipline that under these guidelines is revocation. And then the next line is minimum discipline. So if there is a finding of a violation, the ALJ or the AG's office in settlement, this is the absolute minimum that you will agree to or that the ALJ can impose. Right? So it's, and so it lists then after that 1-16 standard conditions, 33 prescriptions, maintained records, 38 continuing education. So those conditions are conditions that are further described earlier in the document under, I don't know which section they are, but their definitions and explanation as to what those conditions are. Right? Do I have that right?
Yes.
Yeah, okay.
And the conditions for probationary terms and conditions, there's really three conditions that are in, or three sets of conditions that are in these disciplinary guidelines. There's a standard set of conditions, which is 1 through 16, and that's your general condition that's applied to everybody across the board who's on probation. It's kind of the minimum set of conditions, and that's obey all laws, comply with monitoring, things of that nature. The optional conditions is the second set of conditions. Those are optional, so if this is a situation where none of the optional conditions need to be applied, they may not be. It just might be a situation where the person's placed on probation for 3 years and they just have to check in with the board. The optional goes a step further and says, not only do we want to keep an eye on you, we think you need some additional assistance to ensure your safe practice. So that's where you have the possible therapy or worksite monitor, and then you have a third set of conditions, and that is the uniform standard for substance abusing licensees. That gets triggered if there is a finding that the individual that is being placed on probation has been deemed to be a substance abusing licensee. Then a whole third set of conditions gets triggered of what might be, and within that third set there are standard conditions and optional conditions.
Okay.
So it has 2 additional branches.
But that all flows in from what we say are our minimum conditions under these guidelines, right? That flows in through the standard conditions.
Correct.
Okay. And then, still staying on this example, there's an if warranted section, right? So, an ALJ, for example, hearing a case and finding a violation would absolutely impose the minimum discipline, but then has the option of imposing additional conditions, penalties, etc., under the if warranted section. And again, those if warranted sections are like 22 worksite monitor. That's defined earlier in the document. Correct. Okay. So what the committee tried to do is we looked, and based on staff's recommendations, staff recommended a number of changes to the minimum required discipline and if warranted conditions. And we commented on each of those conditions. In some instances, perhaps the sanction was reduced or increased depending on the violation. So the homework for you is to look at, unfortunately, beginning on page 38 or 35 on the PDF version, is to look at the specific violations and make sure that any changes to the minimum or if warranted seem right, okay, are correct. For example, and this tees up one of the issues raised in our legal counsel's memo, one of the suggestions, I'll take the first violation, is to change, if you look at the if warranted section, to eliminate suspension of 30 days or more and replace it with just suspension. That change would give the ALJ the flexibility of, if suspension is warranted, to give anywhere from, to give any number of days of suspension. So if warranted, the ALJ has the flexibility of awarding, say, on the extreme, 1 day suspension, okay? In the course of our discussions, one of my questions was, do we want to give the ALJ that level of flexibility for this violation? Is this violation, excessive prescribing, so egregious that we as a board want to say, if suspension is warranted for this kind of violation, you must impose at least 30 days, okay? So it really depends on the violation, how that meter is set, and I would invite the whole board's input on that. There are some violations like, I point something out, intentional fraud, right? Do we want to give the ALJ flexibility to just award 1 day of suspension, or do we want to say, hey, if you think suspension is warranted, you've got to give at least 30 days. But those are the kinds of questions that the board needs to answer.
So Mark, staying with that one, if I look at 25, if warranted, line item 25 was completely removed, and yet in the comment section it just says remove the 30-day minimum. It looks like the whole line though was removed.
But then they added a 25 that says just suspension. So they actually.
So, okay, but then what do you, what are we to use then when you mention 30 days? Or just give that open door to the ALJ to do anything?
So this change, if the board adopts, gives the ALJ an open door.
Do you have anything for us to use as a tool to guide us? Like what other similar types of disciplinary action that might be out there instead of just saying any and all to the ALJ, any number of days, and yet you're using 30 in your example, is there some threshold somewhere?
I don't know, the 30 is what was in disciplinary guidelines before. So we would be changing it for flexibility.
Okay.
So, in line with what she's asking, what was your reasoning in your committee as to, do you need that level of specificity below 30? Like, what was your reasoning for that, to eliminate, other than just giving the ALJ discretion, I get that. But is that necessary, like, to give like a 1-day suspension to, like,
So-
It triggers, so it's triggered.
So.
but I mean, I'm just saying 30 days isn't that much, I realize it is, you
Yeah.
know.
Well,
So-
I mean, we can go the other way too. I mean, I guess, the elimination of the specificity of the 30 days was proposed by staff. The reasoning was to give staff greater flexibility in negotiations and greater discretion to the ALJ.
And ultimately the board, because the board's deciding,
Right.
you know,
Right.
the cases that.
Well, it's like a big deal, what I'm asking is, it's such a big deal, because like, again, just looking from the outside in, 30 days doesn't seem like such a big deal, right? So, for those of you that are negotiating, is that necessary, is that like a significant piece that you need to use for negotiating these types of things?
You can provide a low end and a high end where you can say 15 to 90 days. So that gives some wiggle room during negotiation as to what is most appropriate. But the question would be if suspension is appropriate at all for this violation. And if you determine it is, then perhaps you could do from 15 to 90 days or however much you think such a violation would warrant.
So why,
So you're looking for more specificity?
well, that's a decision that the board may want to discuss. My concern initially when I saw this is for some of the more egregious violations, I did not want to give the ALJ complete
Yeah.
discretion.
And that, I guess, maybe this is a bad example too, because I'm like looking at this going, you know, but I get it,
Right.
Okay, that
I
makes
think
sense.
the other one was like gross negligence, fraud,
Okay, that makes sense.
unlawful referrals,
Okay.
fraudulently altering medical records.
Yeah.
Yes,
I would want to make the minimum actually be 30 days with no discretion. It's 30 days should be the minimum.
Yeah.
In egregious.
So that's the point.
Okay, that makes sense.
I have a question. Being that this was already in there, you know, what, has it been challenged, like, this doesn't work? Have they ever come to that point and say, you know, given the 30 days, it just doesn't, we want something better? Have you seen cases like that something should have been different?
So usually if that is part of the guidelines, it is still reviewed on a case-by-case basis because there is the ability to deviate. So if in an instance where there was excessive prescribing of treatment and it might have been one incident, it was minor excessive, or there's a lot of mitigating circumstances around it, the staff can choose not to require that be a condition. But there has to be justification for it, so that when it comes before the board and we're saying we deviated from the guidelines, there has to be a reason why that deviation was done, so that the board can determine if they're going to adopt it with a deviation or not.
And there are cases and have been cases where maybe a suspension was in the if warranted section, but it seemed like it really fit the case. But a minimum of 30 days, I know it doesn't seem like a lot, but for a lot of licensees, you're not earning money, your patients aren't being seen. If there are emergent circumstances, somebody who's been to you for so long would have to seek other care. They kind of balk at having to be suspended for 30 days. So it can be something that kind of hangs a negotiation where we may feel that suspension of 10, 15 days would be appropriate. If there's a minimum set at 30 days, then we're looking at either suspending somebody's license for 30 days or not including the suspension term, because those are our choices.
And this is a disciplinary guideline that, if I heard correctly, you can be using on cases that don't even come to the board.
In negotiations, right?
in negotiations for those cases?
Negotiations are the settlement, the stipulated settlement cases, those still come to you for final approval.
Okay, are there any that will not come to us for final approval?
From the disciplinary guidelines and
Okay, so everything does still come back to us.
And we do take this as staff in our settlement negotiations. We take this as the board's direction. So if we have charged excessive prescribing, we take this as your expectation when you see this decision is that it's going to have these terms.
And my other question is, when we do our homework, can we come back and ask what other boards might have as certain thresholds? So we'll just, where do we send in our homework responses? Which, to Rob, to Joanne, to then pull together for the committee? Right, Vina, or do you want it?
I'm just thinking about it. I know yesterday we decided that there's some substantial work on even changing the organization of this and a lot of the introductory stuff that we would do for the DOC guidelines. And I was just thinking it makes sense to make, to the extent they can be consistent, and there's no issue about, these specific violations, but it's just a matter of making it clearer for example, where the uniforms, we've seen a lot of times ALJs think the uniform standards are actually the proposed order, or that text that should be implemented, and that's not what those are meant to be. So we're thinking about doing some more work on these guidelines and bringing it back to the Consumer Protection Committee ourselves as staff and legal, and with Ms. Crawford's help as well. So I don't know if that can go on concurrently with your homework. Or if you just want to wait.
When it comes to suspending for excessive prescribing or treatment for something quite egregious, I'm wondering what the med board does and where they see
And I'm
what
sorry,
their
we were
definitions
going
are.
to look at I think it was the Ellen.
The Licensed Vocational Nursing Board, the Pharmacy Board, and Board of Registered Nursing.
And because those are the ones that are very familiar to a lot of the ALJs, so we want to try to not model, but make sure that we're at least using those as resources to
Having
give you some feedback.
a chart would be really terrific, that here's existing, here's proposed, and then list the 3 or 4 comparative boards that you'll be using throughout, so we can do a comparison. That might help with our homework assignment.
So one thing I just would have as a question for the work group is, did you consider, so I noticed that there's things that are more specific and there's some things that are less specific right now in your recommendations. And have you thought about what that could mean when we hear cases about what we may start receiving from the ALJ, and that there might be a lot of a risk of increased variability versus we could see improved consistency also. So did you take that into account as you were making your initial recommendations about what that's going to mean for when we actually have to hear cases?
Kind of, sort of. The less specific we are in terms of what.
Right, there's a pro and con either way.
Right. The less specific we are in a penalty, right? The more the ALJ has to figure out what to do and explain it, right? So that, I guess in a sense, maybe putting more work on an ALJ.
And possibly on us ultimately.
Right, and possibly on us,
Don't
right.
completely agree.
Right, because,
But in general, it's more, you were being more specific in your recommendations than broadening most things.
Suspension's a good example. It's like, it's just broadens it a little bit.
That's a complete broadening, but a lot of the other things will be more specific. So I'm just was thinking about that, and that'll be what I'm thinking about when I'm doing the homework.
Yep.
As part of the work.
Sorry.
I was the one that pushed for removing the 30-day minimum, and I think it was based on what we had discussed about it being hardship for some of the doctors. But now I'm looking at it from all the perspectives, going, oh, that makes it harder on us, when we're trying to determine what we want to do for these people. So I want to go back in and look at each one of these violations and determine a minimum and a maximum. I think it's going to make it easier for everyone in the long run. I don't like leaving it as just open suspension. And I originally, I was the one that wanted to do that, so.
Because what I can see us getting caught in is what precedent do we set? And then having staff go back to all the various similar cases. What did we do for person X? Why did we do this for person Y? It comes back and a legal challenge to us that it was overly excessive or whatever it may be. And now we're caught in a quandary because we have something that is so vague.
I rescind my original thought.
Yeah, no, that's okay. It's good thought.
I understand like the hardship piece for the provider, and not that you want to be not sympathetic, but you broke the law, right? And it's not like, we hear so many different cases. I never hear a good reason, there's really never a great reason. People have extenuating circumstances, things happen, people make mistakes, right? So if you look at it when people make mistakes and you want to give them a chance to fix it, sure. But I don't know that I've ever heard a good reason for why someone broke. You're not supposed to do that, right? So saying that a one-day suspension, and it's true, because if we hear a case and the person comes in and gives whatever reason they give and we're swayed for 5 days, the next time it's the same case, but not so articulate a speaker, right? And they don't know how to present the points as well. So we say no, 30 days. It leaves us, I think that's kind of the crux of what is being said. So so we should at least have some kind of.
And the hardships on the patients themselves, I flip that to say, as the doctor, they've got a lot of explaining to their patient why now I'm not able to see you. Gee, I'm really sorry, but I overprescribed it. It caused someone to go into cardiac arrest. I look at it as we're further protecting the patient in the long run and the consumer, overall consumers. Maybe it's better that person has to refer people elsewhere if you've got a doctor who's misbehaving.
So let me articulate, since the board gets my concern when I.
Yeah.
But let me articulate an argument initiated by staff, which makes sense. It's kind of a to say its efficiency kind of undercuts it. But if the guidelines are too harsh, then when there are settlement negotiations,
They don't have that wiggle room.
they don't have the wiggle
We get
room
that.
to settle cases, and then all cases go to hearing or whatnot. And those are the extremes, right? And we can find, and it's our role as a board to kind of tinker with it and come to as best of a medium as we can.
So do you want us to do homework now, or are you suggesting that this might go back to the committee one more time? I heard
Staff, though I'm not excited about it, staff has indicated that because of what happened at the DOC, that these guidelines go back to committee to input what happened at the DOC. They're flipping, they use these guidelines as a model for their guidelines and chop and paste it. They probably suggestions, I guess, that might be applicable to the optometrist guidelines, so that maybe the committee should consider those suggestions as well. Perhaps in that process, earlier input is better.
Okay.
So, rather than waiting for this to come back to the board meeting, if board members have ideas, opinions, suggestions as to particular violations, I think earlier is better.
Yeah, I think that's important, because if you can give me an example, like in this particular case, it would have been helpful for 2 weeks. Do you think that 2 weeks is appropriate, right? That's a better question than can we leave it wide open, right? So in this case, we have a range of this to this. Yeah, but that kind of stuff is better, I think, because that gives us a better range, more definition, and we don't get stuck with the.
Arbitrary, just
Yeah.
being arbitrary.
That's great, does that make sense?
To help in that struggle, there's also options where you can have maximum, minimum, and moderate discipline that the board can recommend. Also, the guidelines are guidelines, and it says right on page 30 or 10 of the guidelines that the board recognizes that sometimes deviations will occur from these guidelines and simply requests that the ALJ provide a reason why they may have deviated. So they can deviate from the proposed maximum discipline. They just need to explain that so the board understands why certain terms were not imposed, or were not imposed, the 30-day suspension wasn't imposed, maybe 15 days, maybe nothing was imposed. And it's the same thing in settlements. We do at times deviate, but the DAGs have to provide an explanation as to all the information and evidence they've received, why that deviation was justified, and the board can then determine if they agree or not from that deviation. So there is built-in deviation permitted. That wiggle room
Yeah.
is in there.
So maybe we don't need to be so.
I think we had a really good time yesterday because you brought up what the nursing board was doing and explaining this really works, and the way that they were reading it, it just made more sense, and that's why it was easier for us to kind of amend and copy and paste. And
Can you give a for instance?
Well, we were talking, we were going paragraph by paragraph and looking at each one, and it's saying, it doesn't really apply to what we do as opticians. And it completely said, let's take out these paragraphs, I'll look it up right now, take out these paragraphs and let's see what the nursing board uses instead, and we just replace it there. And I'll look up an example, I do remember a few of those.
And Mr. Casella
It
participated.
was there, yeah, he was there as well, and we also had Mia. We had 3 attorneys there, and they would expand on it. They would expand on things and explain, this is what, it's best for the opticians. This works for them, why are you bringing that? It doesn't make sense to put that in. And then reading those paragraphs from the nursing board, what has been working for the nursing board, it made more sense.
You do have to consider the professions, they're not, I mean, it's
Right.
yeah, they're not totally aligned.
Right.
And even optometry and opticianry are not.
Yeah, they're
totally
not,
aligned.
and that's why.
So-
But what does the medical board do? I mean, there's maybe a little bit there, but the doctor, I don't know.
Question, who decide, I'm looking at deceptive advertising. Who would decide if that's something that's worthy of a citation versus worthy of the Attorney General dealing with it and going to an ALJ? Is that something that the EO or the usury, or who handles that?
The executive officer is the one that has the authority to issue citations. So when that case comes in, that determination is made at the staff.
So the executive officer says, I'm just gonna issue a citation on this, but it's something which is more egregious that really should have gone for adjudication with an ALJ. Would you review the EO's decision, or is the EO's decision final, or?
It's final, it's my knowledge.
I
If
mean,
they issue a citation, that's within their discretion to do so.
There's an
Unless
appeal
we're-
process of the citation by the person being cited, that would eventually go to
Yeah,
hearing.
you won't see it.
But
And
only if
then
the
there is-
respondent thinks it's too severe, right? It's too light.
No one's gonna.
We won't
write
see
it.
it.
You don't see a lot
No
of
one's
them,
gonna
right?
write it.
But you could see them when that's been appealed.
And there are times we also involve on EAT on citations to where we just get our input. I think it's a pretty common practice actually when there's something that seems like it's not as clear cut, it's we involve our office and get the input on there, so.
That's when usually we'll discuss evidentiary issues, whether it would rise to a level where we can pursue an accusation versus a citation.
So I go back to, you would like us to go through and give some high-level comments while we're receiving some details, because the devil will be in the details, ultimately. So just give you some high-level gut comments on this.
Or, more specific on specific violations. I mean, I looked at this from a lawyer / former enforcement attorney's perspective. And So for example, a violation like fraud, I don't want to give the ALJ the discretion to award only 1 day of suspension. I think it should be, at least 30, right?
But these other boards that we're getting a comparative analysis from, that 30 might be 60 or whatever,
Yeah,
so it'd be nice to know.
Yeah.
Okay.
All
right, thank you.
So the other kind of comments I'd like to make are sort of 3 o'clock. I have invited the AG's office and to provide any comments as to what's working in the existing guidelines, what's not working.
Okay.
So we're getting that input either at the committee level or board level. Other issues or changes that staff has identified and that the committee has agreed should be changed. We can discuss them further at the board meeting, but let me just highlight them and remind me if I miss anything. But they're in Nina's memo, or my memo written by Nina.
It's all lawyers speak, it's okay.
It's, so item 2, as we are engaging more into continuing education audits, whether or not to have a separate guideline for discipline there, because currently if there's a glitch or a problem with the CE, we were looking at them under fraud, misrepresentation, or dishonesty, and perhaps that's a little, maybe that's too severe of an avenue to go under. Maybe something specifically CE is more warranted.
Mr. Moradami, I think with that one, and you could, maybe this will help refresh your recollection, I think the staff had an issue because there was no specific violation section for CE fraud, and the...
Was CE fraud or CE mistake?
It would only, they would, I think the discussion was, it wouldn't actually get to an accusation, a discipline proceeding if it was a mistake. It would be an egregious, like you said you did your 50 hours and you really did 3 or whatever.
Right.
And so the discussion was based on, if you look at what's in there now under fraud, there's auditing, medical record keeping course, and it didn't really fit the violation. So staff came up, and I think the committee agreed to have a separate violation section from the sections we were looking at for CE audit failure, maximum discipline revocation, minimum discipline suspension until CE compliance verified. And I think the initial concern was, what if it was just a mistake, a simple mistake? And the discussion was, that would never get to an accusation.
Thank you. Well, that's interesting because I won't get into it until
next go around.
Another change that was interesting to me, or at least interesting to the extent that at least I understood it, is employment limitations. That someone on or on probation under the current guidelines are prohibited from supervising optometrists, and whether or not that is a reasonable or fair requirement or condition. Are there any other things we should highlight now for the board?
I think the uniform standards are something that are going to also come into play when you're doing your homework.
For substance abuse.
For substance abuse, yes. That when you're looking at violations that involve substance abuse, not only is there the standard terms to consider and the conditional terms, but also the substance abusing licensee, uniform standards for substance abusing licensee. And that's where we want to get this packet together so that it's as clear for you as possible, because right now, as it is, the ALJs are very confused by this document. They are putting in conditions, primarily from pages 11 to 23. They're putting in this language thinking these are conditions of the board. and they aren't quite. They're actually instructions to the board on how to handle substance abusing licensees. They're not actually terms to be put into an order or a stipulated settlement. So this is, these first 15 pages are really confusing ALJs, and they're putting in language that isn't really in order.
Question for you, because this is a pretty big project. Should we think about taking some bite-sized chunks here? Would it first help us to look at the disciplinary guidelines piece, for example, instead of all the back and forth, and now we want to change this, we'll come back and we'll be changing that. So let's start with one tool, if you will. Let's nail that down. Then ultimately we'll get to whether it's 1 day or 20 days and 15 days or 12 days. I don't know if I'm there yet, if I'm first hearing that this piece that's used to align is confusing.
I think
Let's get it squared away maybe first, and then do the rest of the homework.
we need to provide you with a workable guideline first, and all the terms being laid out before you can start attaching code sections to terms.
Fair enough.
Okay, so maybe a guide could be to take a look at the introduction through whatever page you'd like us to by a certain date, provide initial comments, you can come back, then we'll take the next chunk. I don't know, it's up to you, but to go through this whole thing and uniform codes and everything else.
I just think I appreciate earlier advice is better, but I think because there might be some, with us working on it, might be substantial changes. It might be better to just leave it, and it could be a big section for the next meeting. I don't know, we haven't talked about future agenda items, but this might fill in a good portion of the next meeting, but it would be better prepared for you.
Okay.
Or you can choose which specific section you
Thank
think
you.
is the most important to bring back to us, so that we address that one first. I can do it.
Okay, thank you. Any other questions regarding this since it's going back into the workshop?
My only comment is to the Attorney General's office on the substance abuse. If you could help us understand what the ALJ's problems are. It seems to be more of a drafting explanation problem than changing the substance or having this board decide on the substance of the condition, but more kind of how it's explained to the ALJs.
You're right.
So you can help us a lot with that. Sure.
Thank you. All right. We'll go to agenda number 9 now, and if we could stay with some high level,
Oh, absolutely. Okay, read as you like.
just key points that we need to be aware of.
Oh, sure. And it's easy enough to, half of these have already been discussed, 1386 and 2138 more in depth by the committee report. I wasn't sure if legal counsel was going to discuss 2461 in any more depth in terms of the FBI wrap back, or if we covered that sufficiently. The other one was 2444. It's on the agenda. I don't believe it's in the materials. It's same status as it was last time the report was dead, unfortunately. I believe it should still be a high priority for Ms. Mission, especially going forward in the next legislative session as far as children's vision goes. The other two omnibus bills that include some non-controversial items that are related to optometry, expiration of license changes. As far as my understanding is there's a 3-year window currently. They're going to remove that window and just have a reactivation of a retired status or of an expiration, not have that 3-year kind of period attached to it anymore. And then the other one is updating the name in statute, go from State Board of Optometry to California State Board of Optometry for consistency's sake across all of statute and publications, things like that. Removing the word registered from in front of dispensing optician in statute, because now RDO is actually a very specific kind of entity. It makes sense in the statute to make sure we're not referring to the RDO, we're referring to CLDs, SLDs, and RDOs. And then updating license expiration dates to go from, I was forgetting this, we're going from the end of the birth month of an OD to 2 years from the last month of date of issue, right?
Yep.
Okay. I can remember which way it goes. So those are the two omnibus. There was one that I wanted to bring up just super briefly that's not on the agenda, but we had that issue with AB 443 as far as the scope of practice that had immunization certification for ODs, and we ran into the problem where CDC doesn't offer any sort of certification program for that. And Senator Hernandez's bill, SB 762, has a hearing next week in Assembly Appropriations, and it adds to that certification from the Accreditation Council for Pharmacy Education. So that'll be fixed, and people can start getting accredited for immunizations.
Thank you. Any questions? Yes, Mr. Mordo.
So, you explained it, but I want to make sure I understand. So, the change from State Board of Optometry to California State Board of Optometry, that's cleanup because there's inconsistency in the statutes and in the laws?
That's my understanding. I wasn't privy to the conversation as to the history as to why they wanted to change it to California State Board of Optometry, but I do believe it's a consistency. Also, all of our publications say California State Board of Optometry, which isn't like legally damaging, but.
You know, we're really busy in our legislative program, and we're short-staffed. I don't want to expend a whole lot of resources and time.
Yeah, this one.
Okay.
It was rolled into this from another one.
Just one line of bill.
Okay, all right.
Yeah, these are little things that Jessica had been working on. Oh, I gotta fix this, and then an AMI came up and.
Yeah, they all got clumped into one. That's part of the bill that's got stuff for 5, 6 other boards as well.
Fine.
But if you want to go testify before.
Consumer protection demands that we change.
They need to know what state they're actually being regulated in, so it's important that it says California State Board of Optometry. How's that?
Any other questions? All right, thank you. So, update and discussion and possible action regarding the board member handbook, item 11.
So I have that on there just in case anyone wanted to revisit discussion of the per diem issue from last time. I went to go and the board voted to adopt the amendments that were presented and subject to my review. And as I was changing the language, it was clear to me that the board wanted a per diem, $100 per preparation day, 1 day, only if the board member actually attended the next meeting, and then they get the attendance per diem. And that would apply to the committee meetings as well. And the committee meetings, whether it was 4 committee meetings attended, they'd still only get the $100. What wasn't clear to me is there was a carve out for committee meetings. I think it was Mr. I can't remember who mentioned it, but that if there's a lot of substantial work going on with committee meetings, it could be more than $100 if approved by President Brandwein. And there was no discussion, I went back, I listened to it twice, whether that would also be true of board meetings. For example, you have a closed session, 600-page document. So I don't know if anyone spent more than 1 day, but did you want that similar, exception that if for some reason the board meeting preparation is significant, if it's approved, that you could also get the per diem, extra per diem for that?
I'd say no, because we don't give it now. Now you don't even get a preparation day, you just get $100 regardless. So I would just, the only reason we did the carve out was in the case of, practice and education. It may be in the case of the EO search party thing, if there's an issue that comes up, children's vision, where we're spending a ton, and then it's at the discretion of the president.
Okay, I just wanted to make sure that I wasn't missing that issue. And there might be more like email voting and ballots or reviewing my opinion after proposed but not adopt decision. But you guys are all comfortable with, you didn't get it before.
Yeah.
Okay. And then and I think for process-wise, there was a little bit confusion because I think the staff still expects it to be requested. For example, for this board meeting, still expects an email from you saying, I request $100 and $100. It's not an automatic thing because some board members in the past historically choose not to accept it at all or not to ask.
Can you change it and just make it if you don't want it? You let staff know?
If that's the
You opt out? I mean, I guess I'm trying to avoid when I'm busy, we all have day jobs.
Yeah, that
It's
should be,
just-
I mean, that actually would probably be easier.
Yeah,
So
that way we
automatically
don't
assume
have.
$100 pre, $100 for, if everybody says no, they don't want the 100 pre, then.
Yeah, no.
Well, or if you know, okay, so-and-so wasn't at Maria's not here today, she
Right,
didn't
yeah.
make the board, so you would already know that.
We would,
But if
yeah.
I decide, you know what, I'm gonna waive my per diem this month for, you know, I'm making a donation in the state of California, then it's on me to tell you, so you don't have to track everyone down
Right.
and try to do it. So hopefully that saves staff time too.
Yeah, that's perfect.
So I'll do the final edits to the provisional one.
Okay.
Doesn't need a new motion, but I think we could drop that agenda item. Unless anyone else has comments.
Okay, thank you. Future agenda items, number 12. Mr. Wardovey, did you have an agenda item from earlier?
I'm sure like a list, isn't there like a list?
I don't know what it is.
It's not.
No, I meant from today, like, we used to write down, so we go, have suggestions.
Disciplinary guidelines is one thing.
Maybe can I just make that suggestion, because Jessica used to write them down as we were
Sure.
going through the meeting, so as people would say, because I don't remember her. but if you-
Yeah, I mean, I probably have them on here listed, but I'd have to go through, my notes.
Well, there's the disciplinary guidelines and then further discussion on any legal analysis of
And the chopper.
Oh, the OE tracker.